Lisa, go ahead.
What are the
May I have your lordship leave to mention for inclusion, lordship? Lordship, the interim order will expire on the 13th of June of the three matters. May I have your lordship leave to...
If you have given a mentioning slip, send the mentioning slip, it will be included.
Okay, much obliged, lordship.
I'm for the state.
Charge notice placed on 13th of July trial.
Always renew the prayer for bail after the charge is filmed. Chalo, Ashwin. Learned advocate appearing for the petitioner submits that at the petitioner is in custody for 377 days. And in spite of charge sheet having been submitted till date, the charges have not been framed and there has been no progress in the case. Learned aid advocate appearing for the state opposes the prayer for bail and submits that huge quantity of contraband of the gaja was seized from the exclusive possession of the petitioner. And as such, the rigors of Section 37 of the NDPS Act is attracted. Thus, attracted. So the petitioner may not be released on bail. I've considered the submissions of the learned advocate for the state as a petitioner as well as that of the state. And on perusal of the case diary, I'm of the view that this is not a fit case to release the petition on bail at this stage. Consequently, NDPS or CRM NDPS case number 82 of 2025 is dismissed. However, the petitioner would be at liberty to renew his prayer for bail after the stage of consideration of charges are over. Grateful. Yes. Yes, madam.
Lordship, I'm for the state, Lordship.
Only warrant, you are in custody since 217 days. Fifth of November, you were arrested. Commercial quantity come after some time after the, not at this stage. I'm directing for splitting up the trials.
Lordship, kindly record my objection, Lordship.
Learned advocate appearing for the petitioner submits that the petitioner is in custody for about 270 days, and there is there is hardly any possibility of the trial commencing in view of the fact that one of the accused person is absconding. On any on any stringent condition, the petitioner prays for bail. Learned advocate for the state opposes the prayer for bail and submits that commercial quantity of contraband was seized from the possession of the petitioner. As such, the rigors of Section 37 of the NDPS Act is attracted, so the petitioner may not be released on bail. I have considered the submissions of the learned advocate for the petitioner as well as that of the state. And having regard to the submission so advanced, I'm not inclined to release the petitioner on bail at the stage. Accordingly, CRAM NDPS 154 of 2025 is dismissed. However, the learned trial court special court is directed to issue harsher process of law so far as the absconding accused is concerned, exhaust the process of law and thereafter split up the trial so that the CAA may be progressed in due course of time.
Grateful, Lordship.
Yes, who is for the petitioner? Learned
For the
advocate appearing for the petitioner do not intend to press, do not intend to press the present bail application. Learned advocate aid for the state is present in view of the submissions advanced by the petitioner. CRM NDPS number 175 of 2025 is dismissed as not pressed. Next.
Lordship, I'm for the petitioner.
Yes.
Day before yesterday, the matter was heard.
Where is your counsel? Who is
Lordship,
appearing for the state?
Arjun is in court number.
short pass the ball, Lordship.
12 o'clock.
Grateful, Lordship.
After 12, after I give the first break, okay? Court pass over.
My lord, item number 5, claim for short passover, my lord.
Why?
My lord, my conducting advocate is appearing in court number 3, my lord.
842 Yava tablets, my lord, commercial quantity.
Let the counsel come 12 o'clock. Come at 12 o'clock, sir. I won't give, I will proceed with the case. It's a pass number follow, na? Pass over.
I'm for the petitioner, my lord.
Who is for the state?
For the state, I'm praying for a short Passover, Lordship.
How much short?
Lordship, 5 minutes, Lordship.
No, 5 minutes, no 5 minutes business. Come at 12 o'clock, sir.
Lord, in 7, I'm for the petition.
7.
Lord, intermediate quantity of contraband. 10 bottles of custodial, my lord, and
Who is appearing? Mohajala holo.
Should Mr. Bishash is there, Lordship? Please, please come.
অনিরুদ্ধ বিশ্বাস
Yes, Lordship.
আরে বাবা বিরাট উকিল হয়ে গেছে তো হ্যাঁ পাস ওভার কাম
12, my lord.
12 o'clock, yes.
Rinku Dash, okay. My lord, I'm for the petitioner.
Yes.
Lordship, I'm for the state.
My lord, the allegations are under sections 8C, 20B, 2C and
32
29.
kgs of gaja.
Yes, my lord.
32.134.
My lord, charge sheet has been submitted, my lord, without the FSL report. My lord, after submission of charge sheet, my lord, 7 months have passed, my lord, till date the
Why FSL has not been submitted till date?
Requisition has been sent, but could not collect it. They have not. sent
Convent
it.
Road, where this Jalpaiguri.
My lord, it was sent on 10th of November 2024, my lord.
I want to see if they have any difficulty, inform. Friday I'm keeping the matter. This চলে আসুন লিখে দিই না হলে ওর অর্ডার না দেখালে দেবে না Learned advocate appearing on behalf of the state submits that the petitioner is in custody for about 700 days. Would stop. Learned advocate for the state on the other hand submits that the FSL report has not yet been received. The investigating officer of the case is directed to collect the FSL report immediately. Full stop. The director FSL Kolkata is hereby directed to ensure that the FSL report is handed over Monday or Friday. Friday may be
Next week,
difficult.
next week,
Lordship,
next
Monday.
Wednesday, no, possible. Is directed to hand over the FSL report by 16th of June 2025. Let the application be listed on 17th of June 2020.
Grateful, Lordship.
Under the same heading, Chul.
My lord, I'm appearing for the petitioner.
Who's there for the state?
9. I'm for the state. My lord, yesterday this matter was heard, my lord. My learned friend was asked to ascertain whether there was a lady constable which was accompanying the petitioners, my lord.
My lord, as per the memo of arrest, there is no such name.
Even on the chat sheet.
And
it is
in the
lady.
forwarding, name is not there, only lady person was accompanied me, that's it.
Where is the forwarding mechanism?
Lordship, in the charge sheet, there is no lady constable or officer which has been cited, Lordship.
At the lady constable, how will be cited? Lady
Lordship-
constable accompanied you
Lordship,
to
the
court.
memo of arrest, Lordship. Lordship, the signature is of one Binoy Jadov, Lordship. The arresting officer.
Are you were in a hospital?
Yes, Lordship. The
So you-
Lordship, from the hospital.
So your
Lordship,
body was not touched.
Lordship, from the hospital, one male officer took me from the hospital to the police
But
station.
you accompanied. Abaki. Have you taken up that point earlier or first time before the High
No,
Court?
no, Lordship, first time,
Lordship.
Lordship, Lordship, have not, Lordship, this point has not been taken up, Lordship. Lordship, on the last occasion when it was rejected, Lordship, it was only on the fact that that Toto Caesar and how it was taken to the police compound and the Caesar was done.
Recovery is how much?
Lordship, it is 96 bottles of cough syrup and Lordship 13 kgs of gaja. Lordship, the 96 bottles of cough syrup, they have not specified the manufacturing date, the labeling, nothing, Lordship, the expiry date, the manufacturer, batch number, nothing has been specified,
Those
Lordship.
are question of facts. If they specify everything, how you will get an
Lordship, 4 bags have been recovered.
How many days you are in custody?
Lordship, I am in custody for about, Lordship, a little above 6 months, Lordship.
Stage of the case
Lordship, charge sheet has been submitted, Lordship.
and
on
Charge sheet submitted on
Yeah,
30th.
30th of April, Lordship. 30th of April, Lordship, charge sheet has been submitted, Lordship. There are
you
12
canvass
witnesses.
you canvass these points which you are taking up before the learned special court. Thereafter come to the High Court after consideration of charges. Not at this stage. So
Lordship, it was only about this. Lordship, the ladies, Lordship, they 10-15 they were arrested, Lordship. Lordship, they were not even, they were injured, Lordship.
arrest was notional arrest, sir.
Lordship, they were taken, yes, they were taken from the hospital, Lordship. There was no lady officer accompanying all throughout, Lordship. Lordship, the accident took place at 5 in the evening, Lordship. The arrest is at 10:15 at night. Lordship, they had adequate time to requisition a lady officer. Lordship, the lady officer could have accompanied the accused, Lordship.
Could have, but then the nurses were there at the hospital.
Lordship,
Chun.
Lordship, they were brought to the police station.
I could have understood Caesar and section 50 was done by male persons.
No, Lordship. Because Caesar was in the absence of the accused persons.
So therefore,
It was taken to the
personal
police
search was not conducted.
No, Lordship, no. They were in the
Personal
hospital.
search was.
It was not conducted.
Only the thing is that they were on the Toto, which made an accident.
I'm recording his submission. He has raised a question. Let him agitate that before the special court. After the charges are framed, you renew your prayer for bail. So,
Lordship.
learned advocate appearing for the petitioner. Petitioner or petitioners?
Lordship, petitioner. There are 2 petitioners, Lordship.
Petitioners submit that surprisingly, the petitioner have been forcefully implicated in connection with the instant case when they were injured and admitted at the hospital. It has been further submitted that at the time of arrest, no lady police officer were present, and there has been clear violation of the provisions of the BNSS along with NDPS Act in respect of the arrest. So effected upon the present petitioners. Learned advocate 8 for the state, on the other hand, opposes the prayer for bail and submits that the forwarding report reflects that lady police personnel accompanied the petitioners when they were produced before the court. It has further been contended on behalf of the state that the petitioners were arrested from a hospital when they sustained an injury on the basis of evidence collected from the available persons when the incident took place. and the police authority is had to conduct an initial inquiry, thereafter proceed with the case. Further, it has been submitted, no personal search of the petitioner was carried out. As such, there has been no violation of the provisions of law. Be that as it may, the issue relating to the absence of any female police personnel has been first time canvassed before this court. First time canvassed before this court. Petitioners are granted liberty to canvass this issue before the learned special court. Full stop. Learned special court would go into details of the records. If required, call for the general diary entries from the police station concerned and assess the modalities of the arrest so effected by the police personnel before arriving at its conclusion. From next. However, having considered the seizures so effected, which are of commercial quantity, I am not inclined to release the petitioners on bail at this stage. Petitioners would renew their prayer for bail after the stage of consideration of charges are over.
Lord, 96.
ওখানে CRM NDBS টা ঢুকিয়ে দিয়েছে। ওখানে চাপ হয়ে যাচ্ছিল না, অনেকগুলো পাঁচও বাড়াচ্ছে।
For the state, my lord.
Yes.
Yesterday, they have provided me Xerox copy.
That day, my lord, and evidences copy. The independent Caesar witnesses were handed over to the state as per the direction of the court.
Is, what are you saying?
Lordships,
Your witnesses have become basically hostile.
yes, lordships, but I found one, I became ostracized, lordships. After when they became hostile, they never made any hostile
You
declaration.
did not declare that, so that evidence has gone.
But one another.
You could have given an application for recalling of the witnesses.
Yes, lordships, otherwise the entire
Evidence,
case.
yeah.
Yes, lordship. And I have gone through it and I found that even the not raised before the court that called as a hostile witness and thereafter prosecution cross-examined.
I thought that you have got to recall that witness and
Yes.
re-examine them and otherwise how it will be done.
And lordships, another aspect of your lordships, this person Prayagra is a man of Sikkim, lordships, out of state, and after getting bail, his appearance maybe
Local, as usual, title deed of our property, sir. As
otherwise
usual.
it will
Because
be
very difficult, because the fate of the case at this stage
yes,
is
lordship.
tilted in favor of the accused.
Yes,
sir.
lordships. But in near future
So,
and lordships, his appearance.
I'll secure that, sir.
And lordship, I have just one object. My objection kindly be noted, and another I will submit before your lordship that previous one bail application filed by Honorable
Bail.
Justice Chairman Lobati turned down their applications that they not suppressed, not mentioned in the application, in this application. They have suppressed
Oh,
this
actually.
fact. Suppressions. And lordships, they have provided this certified copy, so it may kindly be kept in record. Otherwise, it may be anything can be happening in the
Record, I will
basis.
keep everything.
Lordship.
But for a Sikkim person is making an independent witness hostile, take care of that.
Lordship.
Huh? I could have understood a local person has made somebody, some independent witness hostile.
Lordship.
An accused of Sikkim is making the local persons hostile. চলো, কি মামলা করবে সব। আচ্ছা, learned advocate appearing for the petitioner has made available the copy of the evidence of the independent witnesses being PW3 bracketed Noresh Guru and PW4 Bimol Kujur, Kujur. Kujur. Bracket close. Full stop. Learned advocate relied on the evidence which has surfaced in cross-examination and emphasized that the seizure which is claimed by the prosecution is questionable in view of the evidence which has been deposed by the independent witnesses. Learned advocate, as such, the petitioner may be released on bail. Next paragraph, learned advocate appearing for the state opposes the prayer for bail and submits that commercial quantity of contraband where C is from the possession of the petitioner. The earlier rejection order in CRM NDPA is
Lordship, sorry to
8854.
intervene, Lordship, sorry to intervene. Lordship, in the seizure it is found that the witnesses are different names, Lordships. Sorry to interrupt you, Lordships.
This is a nil Caesar list. Where is the Caesar list? Why are you giving the nil Caesar list? Where is the Caesar list actually? Contraband Caesar list. CRM NDPS.
My lord, in this petition, case number
854 of 2023 has been suppressed by the petitioner. Further, the petitioner happens to be a resident of Sikkim. As such, there is every possibility of the petitioner fleeing away from the process of law. Have you got it?
Raju, name of the witness, Raju Burman, Arjun Taman. Actually, Lordship, in this case, there is a two seizure list.
Huh?
Huh?
What, Naresh Gurung is not there, Bimal Kujuri is not there as independent witnesses. पूछे देखी केस जाएगा केस जाएगी देख Give me the case diary, let me see. You have not found the name of these persons. Okay. So fast day Caesar, it will be available. Huh? Have you got? Or no, have you not got?
So may I take short person, just actually I called the IO, but IO didn't turn up.
IOs will not come, sir. IO have done their job.
my lord, four examined, my lord, two civic volunteer and two independent witness, my lord.
Huh?
Naresh Guru
And Bimal Kujur.
and Bimal Kujuru. I
No, no, you will not get the original. You are checking the original case diary.
Lordship, they have said that they have.
At the original case diary, you will not get that has gone over there.
Yes, Lordship.
Exhibit হয়ে গেছে তো।
Exhibit.
Next. ঠিক আছে, I have considered the materials available. I have considered the evidence so relied upon by the present petitioner, the stage of the case, and the petitioner being detained since 6th of May 2023. Having regard to the period of detention of the petitioner, which is more than 2 years, I'm inclined to release the petitioner on bail. As such, accordingly, the petitioner would furnish bond of rupees to bond to the satisfaction of the learned special court with two sureties of like amount each, one of whom must be local. Full stop. The local surety in this case would be by a person who would submit the title deed of his
Highly
property,
obnoxious. Otherwise,
which would be kept in custody of the court to till the trial of the case is over. Gallo. The petitioner shall make himself available on each and every date of trial. Each and every date so fixed by the learned trial court, and would cooperate with the progress of the trial of the case. Full stop. Next paragraph. In case there is any violation of the conditions, the learned special court would cancel the bail without further reference to the AS court. Accordingly, CRM NDPA is number 214 of 2025 is allowed.
Published.
Actually, get a copy of the evidence, photostat copy of the evidence so supplied by the petitioner. Be careful with the record.
Item number 11.
Who is for the state? You are appearing, Mr. Chakraborty.
My lord.
Total delivery 20 kg, 235 grams.
How many days? How many days?
I'm custodial 152 days, 2 accused.
Charge sheet
2
submitted.
days.
Charge sheet submitted.
The case of January 25.
Charge sheet submitted.
Charge sheet submitted.
Charge sheet submitted on 30th of May, my lord. But within time, charge sheet submitted. We should get an opportunity for a custodial trial, my lord.
2 co-accused granted bail by this honorable court.
So bullshit.
I annex last circuit bench.
আর কিছুদিন থাকুক না কি বলছিস prosecution হ্যাঁ চলে আসুন চলে
When you are
আসুন
filing within
I
time,
for-
my lord, everything done within time, my lord.
এটা পরের সাইকেলে যাওয়া উচিত পঙ্কজ বানসাল দেখিয়ে বেল পেয়েছে
My lord.
হ্যাঁ
That cannot be the ground, my lord.
হ্যাঁ দ্যাট ইজ ঠিক পিটিশন কেন কি করিস কেন অন্য কাউকে বার করে নিয়ে যাচ্ছে না তো হ্যাঁ 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 Indian learned advocate appearing for the petitioner submit that from the custody of the petitioners about 20.235 kg of contraband of the gaja were recovered and they were arrested on 31st of December 2024. And since then, they are in custody, full stop. It has further been submitted that the charge sheet has already been submitted. As such, the further detention of the petitioners are unwarranted. Okay. Next, learned advocate for the state opposite is the prayer for bail and submits that there is every possibility of the accused persons fleeing away from the process of law in case they are released on bail. Full stop. I have considered the stage of the case, the quantities of contraband seized, as well as the number of persons involved in the offense, as also some of the accused persons being released on bail. Having regard to the same, I am of the view that the prayer for bail of the petitioners should be allowed. As such, the petitioners shall furnish bond to the satisfaction of the learned aid special court in the form of 2 sureties, one of whom must be local. The local surety is in this case would be of persons who would submit a title deed of the property, which would be retained by the special court till the end of the trial. Gallo. The module, huh?
Circuit, there will be a lot of modifications.
You are going to resist that, sir. You are there for that only. আচ্ছা ইয়ে করুন আর একটা কি ছিল আচ্ছা the petitioner shall make themselves available as and when the dates are fixed by the learned trial court and would cooperate with the progress of the trial of the case. In case of violation of any conditions of the aforesaid conditions, the learned special court would be at liberty to cancel the bail without further reference.
Yes.
According to CRM NDPA is 222/2025 is allowed. ওপরে একটু একদম first sentence দিবেন. Leave is granted to the learned aid advocate of the petitioners to correct the cause title. To correct the name of the petitioner number 1 in the cause title. Well, who is for the state? Hmm. 36.
Where it has been stated that the arrest of the state petition was in from the the team number here towards our area under PSL. Here towards our, it's a public. But I am surprised to see from the resolution about the name of it. How does section 36 of the P of the DN has been violated? Kindly produce the Caesar list first. No independent witness was present. At the daytime, they alleged that they have recovered from the same place near a public.
This is a question of trial, sir.
Right.
Kindly appreciate lordship.
There are judgments to the effect that only on the evidence of police authorities convictions can be there.
In respect of the name of parents, there was no local person. Neither. What happened? The signature of the ASI was been taken down. And kindly of the choice must be kindly lawyer an error from inspection made.
Page.
Page. And
It should take.
it should be what? What it appears that the ASI is neither the local person nor the relative. And you know, currently see the column 2. The GT number has been written as well as the PS number also. How come at that time?
Oh, those are kept, then those are.
How come at that time? Because when the sumo has been that case was been established, was been initiated, the GT number has to be registered as well as on the basis of the GT number, the arrest memo has been prepared at the instant of this case. How come the PS case number has been appeared in the arrest memo?
Is PSGD entry number, not case number.
It's written.
Second.
First the GD&D reference number is given.
This refers to the PS.
That is within bracket, this refers.
31 of
This is not case number, this is GD entry number.
Now, next.
How can two numbers be there, 361 and 366?
Yeah.
Thereafter where?
This refers to the
Jayagraph.
PS case number 31 of
So this was prepared obviously at the police station.
No, it was not prepared in the police station. My lord, things happen, what happened?
And the old criminal law, what it appears on B, 41 B, that it has to be prepared at the instant of the place of operation. And you, as far as my knowledge, it has to be on the basis of the GT number. How come the PS number appears in the arrest?
In all cases, the memo of arrest as well as in some seizure list also, my lord. It's kept planned, my lord, later GD, it has to be, whether it is related to the GD number or not, the PS case number. And moreover, tramadol, my lord, we have received the report, tramadol is there, so it is within the NDPS, my lord.
Learned advocate appearing for the petitioner is issues relating to the seizure list as well as the arrest memo. And submits that the petitioner has been falsely implicated in connection with the instant case. It has also been in canvas. It has also been in canvas that the manner in which the arrest memo has been prepared would reflect that the same was subsequently prepared, which is in clear violation of the guidelines later on by the Honorable Supreme Court in D.K. Basu's case. the petitioner as such, according to the learned advocate, should be released on bail. Yeah, next paragraph. Learned advocate for the state draws the attention onto the contents of the CCD is wherefore all it is found that 13536 capsules of SPS HEN plus was seized along with 23004 capsules of the same contraband from the exclusive possession of the petitioner. Charge sheet not submitted or submitted?
Charge sheet not filed. We have just received the report, my lord.
Charge sheet submitted.
No, charge sheet not submitted.
You are in 120 days in custody. Full stop. The investigation of the case is still in progress. Full stop. I have considered the submissions of the respective parties. I have considered the submissions of the learned advocate appearing on behalf of the petitioner as well as the state. And having regard to the stage of investigation of the case and the regards of section 37 of the NDPS Act, I am not inclined to release the petitioner on bail. Accordingly, CRM NDPS 225 of 2025 is dismissed. Next.
My lord, 39, paying for 1 lakh accommodation, CD is not.
Not today. Come tomorrow.
Lodge, grateful.
Statement.
I'm for the petitioner. Charges under section 6 and 18 of the POCSO Act. The petitioner is a custody 122 days.
164.
Six.
Yes, this is another. Great.
One matter I have granted be like, means yesterday some,
Not in this.
just 1 minute, sir.
My lord,
1 minute, sir. You are Meena Rai. Charge sheet under which section?
charge sheet, my lord.
Age of Meena Rai? না আমাদের মতো করেছে আর কি।
Yes, my lord. 3 subsection 5, 85, 80.
Huh?
3 subsection 5, 85 and 80. BNS.
So 103 is not there.
No, actually, there is nothing against this.
Chalo.
But my lord, the victim, victim is 7 months pregnant at the time.
But that's the husband's fault.
Yes, my lord. He is in custody.
When I look at appearing aim for the petitioner submits that the petitioner is the mother-in-law of the deceased who has been implicated in connection with the incident case. Additionally, it has been submitted that the main thrust of accusations are against the husband who has been arrested. Husband in custody or bail? Who has been arrested and is detained in custody. So far as the mother-in-law is concerned, there are omnibus allegations, and as such, the she may be really she may be favored with an order of anticipatory bail. Learned advocate for the state has produced a case diary, drawn the attention of the court to the medical documents along with the statement of the witnesses as well as the FIR. It has also been submitted that the investigation of the case has been concluded. Having regard to the present stage of the case and the complicity of the petitioner, I am of the view that the custodial detention of the petitioner, custodial detention of the interrogation of the petitioner is unwarranted. Accordingly, the prayer for anticipatory bail is allowed. তারপর যা কন্ডিশন আছে লিখে দেবেন, ঠিক আছে? ওই 20,000 করে দিয়ে একটা লোকাল করে দেবেন ওই ইনভেস্টিগেটিং অফিসার, আর ওই 482 করে দেবেন। হ্যাঁ 480 ওই হ্যাঁ ওই যে 438 আর 482, আর এটা করে দেবেন একটু accordingly CRMA হচ্ছে 334 2025 is allowed. However, the order within 6 weeks, this will be valid for 6 weeks. This order of anticipatory bail will be done jabei na to kono din courte. This order of anticipatory bail will remain in force for a period of 6 weeks from the date of this order.
Grateful.
26.
Arresting দিতে পারেন, ইনভেস্টিগেটিং অফিসার দিতে পারেন। এখন তো অ্যারেস্টিং অফিসার দিয়ে একটা বেটার চার্জশিট পড়ে গেছে। অ্যারেস্টিং অফিসার স্টেটেরই তো কেউ দাঁড়ায়নি, 1 day at time কেন? You are there? 1 day time, not today. এটা করে উঠবো।
My lord, in item number 27, my lord has been pleased to grant anticipatory bail to the other two inmates, other accused, my lord. These are brother-in-law and another brother-in-law and his wife, my lord. They also live separately.
You were there.
No, my lord.
There is in case of similarly placed accused
My lord,
already yesterday.
Yes, my lord. Server copy, my junior will hand over, my lord.
ওটা একটু কপিটা দিন তো।
The brother-in-law and brother-in-law's wife, another brother-in-law.
they also reside in the separate mess.
Petition number one is the brother-in-law.
Brother-in-law and another brother-in-law and another brother-in-law's wife. His wife, Gopal Mondal, and his wife, or Sonamoni Mondal.
Sister-in-law.
দিবাকরবাবু, এই একই অর্ডার একটু পাস করে দিন, লিখে দিয়েছি, এইটা খালি এটাকে পাল্টে দিই, সিআরএম এইটাকে একটু পাল্টে দিন। সেম অর্ডার অলওয়েট
Well,
অ্যালাউড। ঘুরে আসি।
I'm grateful to your lordship, deeply obliged.
Password will.
I'm for the state.
Yes.
Just 1 minute, everybody time for my.
আমি আগে বলি নাকি আগে তো হয়েছিল আচ্ছা বলো
Party. They have seen some miscreants coming in order. They have chased the miscreant. They had 50 Kotlas and went to the nearest village. The PSF went till there, apprehended one and others taking the fog, the situation of fog. They returned back and it is mentioned the area was thoroughly searched and 7 Kotlas were covered. But Dr. Karin says the Caesar list in page 14 of my petition. It has been seized as produced by the complainant SI Rajendra Singh Jakar. And also that one pen drive that was seized.
this is re-Caesar. The original Caesar is done.
This is the memo, brother. Also, page 12. They said that it was seized from whom seized Pen-Drive. But in the FIR, categorically mentioned, those articles, those 7 Kotlas were found from the area. Because miscreant fled away towards the village. They chased and apprehended one from the village. And charge has been submitted against 9 probably.
I understand.
9. And my lord, on the other day, instructed the state to see the videography.
But I have seen the videography. Lord, there is indeed a video where Lord it is can we reveal Lord that they were chasing and Lord they fled away. That is one. But the BSF initial seizure by the BSF Lord there is no footage. But the re-seizure there is a footage. Lord, 2 footages Lord I have perused. I have seen in entirety Lord. But how is this Nipenwai associated with the case? Lord, he was Lord during the run chase. Lord 8 fled away and he was apprehended by the BSF. Oh, he was apprehended. He was apprehended. I mean, apprehended as 3 person apprehended or some person who was associated with these bags were apprehended. Lord, he was apprehended and thereafter the allegedly thereafter that the bags were seized, but video to that effect is not.
What is the FIR?
Chase part is there, but seizure part is in the video. In the video.
What should the FIR itself? The area was thoroughly searched and 7 was particular.
So the area is what? তাহলে ওখানে ঢুকলো কি করে হ্যাঁ area is BOP.
Yes,
হ্যাঁ
and he was apprehended from the village because the 300 meters, the village is 300 meters. They chased 300 meters.
Look, these matters had to be considered during the trial. Prima facie there is a case, Lord. But then you don't have anything to show that there is inimical relationship between the BSF and.
Minus that was the person from the village and others taking the advantage of the fog disappeared. And I have already the document of it that he is not the resident of that village. He came to his relative's house and he was apprehended.
So what will that show?
Because in the FIR, my residence and everything has been shown to be that village.
Sir, that whatever is shown, that is a disputed question of fact, sir.
Can you consider one thing, that is, the contraband articles were not seized from my possession, from the area. And I was apprehended after chasing as per the.
So if you leave it, that would be area only. If you run away by leaving the bags, that would be area only.
8 went away.
The 8-9 persons were there. As per the case, presumption is there. Learned advocate 8 appearing for the petitioner submits that the petitioner is in custody since 31st of January 2025 and 31st January And the seizure which has been effected is basically foisting the petitioner in connection with it. Huh?
It will not placed.
Do not press this, sir. Do not press. I am granting you liberty to come after consideration of charges. I'm directing for exhausting the process of law, sir, immediately.
My lord.
So far as the other persons,
Lord.
and if required, split up the trial,
Lordship.
split up the case, and thereafter proceed with the case. Chulam? We eat the seized contrabands. Learned advocate submits that the petitioner has no relationship with the contraband, and he was a stray person who visited his relation's house, and the seizure was from the village at the instance of the who is BSF.
Yes, sir. Lordship, one indulgence, Lordship. This Caesar memo does not contain my signature.
Seizure memo, how can it be?
Caesar memo, if it is seized from me, Lordship, page 12. This is the document that they are trying to establish that it was seized from me. My Caesar should be there, Lordship, my signature, to establish that it was seized from my possession.
This point have you taken up? Or first time taking up before the
Lordship,
High
this is the first time I'm before Lordship.
No, not before the High Court, before the trial.
Lordship. Yes, Lordship. Lordship. Kindly see page, the certified copy I have filed 14/2/2025.
Are they before 14/2? Yes.
Lordship, kindly see. Agree with the he has been falsely implicated in this case and falsely implicated. That falsely.
False is a be.
Lordship, he was not there in trial court. Kindly consider.
These are fast flash arguments actually. At the first instance, you must file the application. Ki bola? The BSF authority, BSA personnel resulting in the petitioner being falsely implicated in the case. Full stop. Emphasis has been made by the learned advocate that the petitioner is innocent and is being detained in custody because of the huge seizures which have been shown by the BSF authorities and subsequently by the investigating officer of the case. Learned advocate for the state, on the other hand, opposes the prayer for bail and submits that 219 bottles of ESKUF were seized from a sensitive area comma 8 of the accused persons are 8 of the accused persons are absconding. Charge sheet submitted.
Lordship.
Yes. And although the charge sheet has been submitted, the prosecution is not in a position to progress with the case. Full stop. I've considered the submissions of the learned advocate appearing for the state as well as the petition, as well as that of the petitioner. And on an assessment of the same, I am of the view that this is not a fit case for bail, as the rigors of Section 37 of the NDPS Act are attracted. Full stop. Consequently, CRM NDPS number 190 of 2025 is dismissed. However, the petitioner cannot opt for however, the equivalent cannot be languishing in jail without the progress of the case. As such, the learned special court is directed to exhaust the process of law so far as the absconding accused persons are concerned. And ensure that the stage of consideration of charges are over by 15th of September 2025. Petitioner would be at liberty to renew his prayer for bail after a deposit stage is over.
Grateful, Lordship.
Learned register may kindly be communicate directly.
You communicate, huh?
Grateful.
I don't know why.
Lordship, I am appearing for the petitioner, ma'am.
Yes, please.
So, my lordship, the petitioner is a lady from whom, my lord, 215 grams of Java tablet, my lord, allegedly recovered by the, my lord, the raiding team, lordship. The petitioner is, my lord, in custody for 119 days. Lordship kindly comes to the FIR, lordships will get. My lord, the search has been made not before any independent gazetted officer or the magistrate, lordship. Even, my lord, the witness is one. Also, my lord, as per section 100 of the 104 of the Code of Criminal Procedure, my lord, at least 2 independent witnesses will be there at the time of the search and seizure. Lordships, no videograph.
Where from where Caesar made?
Lordship kindly comes to the.
Where from Caesar was
It's made from the Kuchbihar railway station, lordship.
made?
My lord, from there they did not get 2 independent witnesses. Only 1 witness they got, and which is in violations of section 104 of the Code of Criminal Procedure. Lordships will get it from the page 13. Lordship kindly comes to the FIR. Page 13, lordship.
842 grams of Java tablet.
My lord's from the petitioners, my lord, 230, lordship kindly considers.
This
My
is
lord,
a joint possession. 3 persons were arrested.
my lord, no, from her, my lord.
How can that be segregated? The construction.
My lord, she has already suffered a considerable period of
What
custody.
considerable?
My lord, and her mother, my lord,
Not even 3 months over.
my lord, her mother is in Syria. My lord is a
Investigation going
disabled.
on.
Investigation.
Not at this.
My lord, all my lord have been, all are in custody, lordship. All are in custody, lordship. My lord,
You will be carrying
my lord,
Java
kindly
tablets.
consider, lordship.
And above
My lord,
above 50 grams is commercial.
my lord, the seizure which has been made, my lord, that is completely in violations of section 50, lordship. The mother of the petitioner is a disabled lady of 65%, lordship. My lord, at any conditions, lordship, kindly grant.
No. Learned advocate for the petitioner submits that the seizure so effected in connection with the incident and case is questionable. And only 115 grams were seized from the grams of Java tablets were seized from the possession of the petitioner. Although from the other accused persons.
But if your lordship,
So
one
it
kindly
should
come
be
to the
assured.
FIR.
627 grams were recovered.
600?
215 and 627.
From the others.
Were recovered. Good stuff. Only it has also been canvassed that only a single independent witness has been cited. And there has been no videography of the search and seizure which was carried out. Full stop.
My lord, one more submission is.
Yes.
My lord, lordship, kindly see the FIR. My lord, the sample, my lord, there is nothing with regard to the collection of the sample, even lordship. Lordship, please
Investigation
see
is
the
going
seizure.
on at this stage.
My lord,
108.
gross violations of, my lord, section 50, lordship. My lord,
Investigation is going on. Madam, come up after as a emphasis has been in laid that the petitioner is in custody since 25/3/2025 and she has to look after her mother who is 65% disabled. learned advocate 8 for the state submits that huge quantity of Yaba tablets were recovered and the recovery was from a railway station. Consequently, police authorities had to take steps in a manner which was compatible with the situation prevailing at the place where the recovery has been effected. Full stop. It is also submitted that the investigation of the case is still in progress. And as such, the release of the petitioner would jeopardize the process of investigation. Having regard to the submission so advanced by the respective learned advocates, I am of the view that the rigors of Section 37 of the NDPS Act is attracted, and at this stage, there is no scope for releasing the petitioner on bail. Accordingly, CRM NDPS number 18 of 2025 is dismissed.
Grateful.
Number 6.
5 नहीं,
For the petition.
5 হয়েছে?
But I'm for the state.
My lord, in this case, I was arrested on 11th October 2024. In total, my lord, 62.735 kgs of gaja was recovered from the Padatik Express.
What is the stage of the case?
For a charge sheet filed without FSL report.
No, without FSL.
Kindly see the page number 17, my lord. Kindly see the page number 17, my lord. At the
Yes.
bottom line, I have not received the chemical analysis examination report from the concerned department.
You take instructions by FSL is not. I believe it's ready. By
Yes,
this
sir.
time.
By
should-
now it should have been.
Learned advocate 8 for the state 8 is direct. Which police station?
My lord, this is
NGP
NGP GRPS.
এইগুলো হচ্ছে যত বদমাইশ এই পুলিশ স্টেশন জিআরপিএস হচ্ছে কি বললাম
242.
directed A to take a report from the investigating officer of the case as to why the FSL report till date is not ready. In case there has been no persuasion, the investigating officer of the case will collect the FSL report immediately within the next 48 hours and submit a report regarding the fate of the case. Full stop. List the bail application. Monday, I'm keeping the matter. List the bail application on 16th of June 2025 under the same meeting.
Gratefully.
Grateful. Number 7.
7, my lord, I'm for the petitioner. My lord, intermediate
My lord,
quantity
I'm for the
of
state in
contraband. My lord, 10 bottles of cough syrup and my lord, 3 grams of nitrozepam.
Investigation complete.
No, my lord, I am on the point of, my lord, statutory bail. Because it is intermediate quantity, we have surpassed 90 days, my lord, and the charge sheet has yet not been filed.
Charge sheet not submitted.
No, my lord. Investigate 317 tablets, my lord, and 10 bottles of cough syrup, my lord. Not submitted. Only the FSL report is, we are waiting for the FSL report.
Why? 10 bottles though, commercial
I
quantity.
think,
My lord, 20
317
bottles.
tablets, 317 tablets.
The 317 doesn't, it's an intermediate quantity. 3170 grams. 3170 mg.
3.17 grams.
Therefore, 3.17 grams.
Yes.
Huh? No. To 10 milligram, you have said 317.
My lord.
More compound, if you add water or any other, the strips also, all the aluminum foil addition is not
No,
permissible.
aluminum foil is not
Ah.
permissible. Only the neutral substances are.
The neutral, so you have said 317 tablets.
My lord.
And each is 10 milligram.
10.
Yes,
10 mg.
That is yours. So if you multiply that, that's the total, that is 3170 milligrams.
my lord.
That means 3.17 grams.
Yes.
So what is that? Falling under which category?
To put the picture.
Intermediate.
Taken each.
Nitrozepam. Intermediate.
Intermediate, they can each. जो गाय जोड़े मामला दिए
10 bottles. Ten bottle is a commercial quantity.
1 liter is commercial quantity of syrup.
1 kg product.
Well, 1 kg codeine is commercial quantity. Here, my lord, it is 100 ml each of 10 bottles. So 1 kg and above is commercial quantity. Beyond 1 kg. Up to 1 kg is, my lord, intermediate.
1 kg is
Up to 1 kg what? What is up to 1 kg?
My lord,
1
see,
kg is 1 kg.
my lord, 27 ml.
কোথায় এটা এনডিপিএস এর বই দিন তো
7 to 8.
1 kilogram codeine is 1 kilogram.
And that's why
My lord, takes up the definition of commercial quantity, my lord, at section 27A. 7A.
27.
My lord, 2 subsection 7 clause A.
Yes.
My lord, commercial quantity in relation to narcotics, drugs, and psychotropic substances means any quantity greater than the quantity specified by the central government by notification in the official gazette. So beyond 1 kg, my lord, as a,
127.
no, my lord, it's section 2 subsection 7A.
Oh.
500 grams is a commercial quantity. Nitrazepam.
Iscaf means what? Codeine phosphate.
Yes, codeine.
One kg.
So greater than 1 kg, my lord, is commercial quantity.
And intermediate plus intermediate? Intermediate plus intermediate? Huh?
My lord, if
So what is the character? You tell me. Two intermediate.
My lord.
yes,
What does it mean?
Commercial, my lord.
2 intermediate, my lord.
Let
Huh?
investigation be
My
complete.
lord, 2 zeros does not make 1, my lord. Both are zeros.
Two one makes a 2.
Yes, my lord.
Lord, here there are 2 zeros as regards commercial quantity is concerned. We are within the intermediate quantity. Only, my lord, 10 bottles of cough syrup and, my lord, intermediate quantity of 3 grams. 3 grams is, my lord, small quantity.
That is what I was supposed to say.
yes.
It is a small quantity.
Yes. 3 grams is small quantity.
I saw 5 grams, I believe.
Yes.
I checked up this yesterday. I found this to be 5 grams.
Yes.
Small quantity. কি করেছে? অন্য রাজনীতি করে নাকি? হ্যাঁ?
Instruction with the
Yes, my lord. Nitrazepam, the intermediate quantity is from 20 grams, goes up to 500 grams. So beyond 500. And, my lord, the lower bracket starts from 20. So I am 3 grams. My lord.
That's what I'm saying.
Yes, it is small quantity.
codeine is 10 bottle, my lord. Let the investigation be completed.
My lord, going by your lordship's logic, my lord, then small and intermediate would make intermediate.
That tilts in your favor.
My lord?
Tilts in your favor.
Yes.
কেন দিয়েছি আমি কেসে বুঝতে পারলাম না। কোথা থেকে ধরেছে? সিজন? হ্যাঁ?
Let the FSL come, my lord, let the investigation be completed. From the
Lord,
boss, my lord. So there
Lord,
is
my
a-
statutory right has also arisen.
False implication. By BSF, my lord.
তা আসবেও না তো। না এটা দিয়ে দিই। পরে কে দেবে আমি দিয়ে দিচ্ছি, বাড়িটা জমা, বাড়ির দলিল জমা দেবে কিন্তু।
Audit দলিল?
হ্যাঁ।
Original দলিল।
Original?
এ পরে কে দিয়ে দেবে আমি বলে দিচ্ছি, তখন কিন্তু ওই লোকাল সিকিউরিটি এনএসসি দিয়ে বেরিয়ে যাবে, আর পাওয়া যাবে না।
Lord, any relatives property papers, my lord?
Huh?
Any relatives property?
But within the jurisdiction of the
Yes.
special court.
Yes.
Literal bloodline, মানে
না blood না, local surety jurisdiction of the special court. That's
Yes.
the law,
Yes.
not the local police station.
Yes.
Special
Of
court
the
has a
special-
big jurisdiction, sir.
Kindly record my strong objections.
আর অবজেকশন তাহলে পরে নেওয়া, যদি ফেলে যাই এটা বেল হবেই আমি জানি,
হ্যাঁ, NSC দিয়ে হবে।
আর এনএসসি দিয়ে হবে। চলে আসুন। Learned advocate appearing aim for the petitioner submits that even if the case of the investigating authority is accepted to be true, the seizures which have been effected are 10 bottles of escaf syrup and nitrazepam 10 milligram bracketed 378 tablets. So far as full stop, so far as the first contraband is concerned, the same is of intermediate quantity.
Not small quantity.
Past escaf is
Escaf, yes.
intermediate quantity. And so far as the second contraband is concerned, the same would come under the category of small quantity. Full stop. The petitioner has been detained from 11th of February 2025 more than 90 days. This is 167 actually, basically, Mr. Biswas.
Yes.
90 days you should have submitted the charge sheet. Akivalam? Have passed since the petitioner was taken into custody, and the investigating agency till date has not submitted the charge sheet. Consequently, the petitioner is entitled to be released on bail. Learned advocate for the state submits that the investigation of the case is still in progress, comma, the petitioner was arrested from a sensitive area at the behest of the BSA authorities. And the efforts are being taken by the investigating agency to conclude the trial within a definite period. Full stop. Next paragraph. Having considered the submissions of the learned advocates appearing for the respective parties, comma, the quantum of seizure and the period of detention, I'm inclined to release the petitioner, one single
Yes.
petitioner on bail. You are from Nepal?
Yes.
अच्छा, local lead लिया है वो. Bill बोलना. As such, the petitioner shall furnish a bond to the satisfaction of the learned special court with with two sureties of like amount each, one of whom must be a local. Also, for the purposes of this case, the local surety would mean in a person having a property within the jurisdiction of the learned special court, and the said person will deposit the title deed of the property as a surety till the disposal of trial of the case. Full stop. The petitioner shall not leave the jurisdiction of
Lord, Khodibari Police Station.
Khodibari Police Station without the leave of the learned special court. And shall make himself available on each and every date fixed by the learned trial court. Also, the petitioner further would make himself available, and the petitioner shall also cooperate with the investigation of the case and make himself available before the investigation as and when called for. Full stop. In case of non-compliance of the first 8 conditions, the learned special court would be entitled to cancel the bid without any further reference to the EA's court. Accordingly, EACRM NDPS number 207 of 2025 is allowed. Till the disposal of the trial. Chalo.
Deeply pleasure.
Next.
Number 28.
Where you go? Where you go? 28, who is appearing?
29 for the petitioner. Lordship.
Who is for the state?
Lordship, this is the
Just 1 minute. You are for the state?
One year. One.
Come tomorrow. Not today.
I'm good.
My lord, in 29, I am appearing for the petitioner, my lord.
I am for the state.
My lord, this matter pertains to, my lord, section 336(3), 3184 and 61(2) of the Bharatiya Nyaya Sanhita, my lord, which corresponds 406, 420 and 467 of the BNS.
You are the broker.
My lord, I happens to be the holder of the general power of attorney. Now, my lord, the grievance of the petitioner, I'm sorry, my lord, the
Not
grievance
with
of the
consideration money, I think.
my lord, no, my lord, that did not happen, my lord. The grievance of the de facto complaint was that when he searched his digital LR, he did not find his name. Now, my lord, this FIR was drawn on month of April. Thereafter, my lord, I personally, my lord, took out the certified copies. My lord, this is dated 16th of May 2025. And, my lord, the name of the de facto complainant is appearing, my lord. Kindly seize, my lord.
That is for the I am not the investigating officer, sir.
My lord, my lord, I...
Yes, sir. State.
Lordship, actually impersonating himself, the accused petitioner executed 5 fraudulent deeds. And subsequently, his name, he got the mutation certificate. And then the de facto complainant lodged a complaint before the BLLRO. And the BLLRO hold a proceeding of an inquiry proceeding and called the accused petitioner, but the accused petitioner remained absent. And after perusing all the necessary documents, the 5 fraudulent deeds, that mutation had been was set aside. And again, it is true. Again, the name of the de facto complaint
But
came
offense
there.
has been committed.
My lord, I did not, my lord. My lord,
No.
there is no deed, my lord, which will
Have you recorded the statement of the
Yes, BLRO statement has been recorded.
No. BLO, no. These persons who were subsequently made owners whose name were appearing.
Yes.
Have you recorded?
Investigation is still pending.
No. Have you recorded the statement of Sanjoy Kumar Singh Durga Chetri.
No, Milord, no deed is there, Milord. No deed is there, Milord. I at least could not find, Milord. I searched.
Their statements have not been recorded. I should.
So with this thick case diary, what are you doing?
Pardon, Lordship?
What are you doing with this thick case diary? The name were there in the FIR as persons who were
Lordship, the fraudulent deeds have been seized.
from whom?
The fraudulent from those persons to whom he sold the land.
That is what I am saying.
But their statements have not been recorded.
Our Caesar list reflects seized from Sanjay Kumar Singh, Abhinash Rai and all this.
Caesar list is not in the case diary.
So how are you going to produce that in court? Ki mamla pore to kothakar
Milord,
mamla?
the de facto complaints grievance is completed, Milord.
The offense has
I-
been committed.
Custodial interrogation, Milord.
How have you collected those deeds?
One day accommodation, I will let I will be called for and take the instructions.
But you have committed the offense, sir.
Milord.
এই যেখানেই সিটি ডেভেলপ করছে সেখানেই এই জিনিসটা হচ্ছে যে যার মতো করে জমি জমা একটা পাওয়ার অফ অ্যাটর্নি নিয়ে করেন। এটা নট টুডে করে দেখে নিন।
Great point.
I am for the state.
Yes, sir.
May I please, your lord? I am on behalf of the accused petitioner, Manoj Roy. I have filed anticipatory bail application. Fact of the case in brief is that, my lord, one,
Only co-accused statement.
yes, I have implicated in this case on gaze only.
Lordship, actually, the
CDR,
BSF,
CDR is there.
Lordship named in the FIR.
Are named in the FIR?
Named in the
Why?
FIR.
By whom? Who drew the FIR? How is he named in the FIR?
Actually, at first, BSF, at first BSF raided them, chased them, and they fled away. One is the owner of the vehicle.
So who divulged the name of this person? The accused who was arrested?
No, all have fled away. One is owner. Owner was not present at the spot. Another is rider. Rider of the vehicle fled away, and another person is the principal again, associate. Effect about
Scenes, actors, and troops.
And the FIR has been lodged by the inspector Vikas Rai Shahu, officer and commander of the BSF.
No, just tell me all the persons fled away.
The owner was not present in the vehicle. Yes, fled away.
Nobody was arrested.
Nobody was apprehended. And after BSF seized the contrabands, the police rightly resisted from the BSF.
So he is on the same footing as this person, Subhash Chandra Rai.
Subhash Chandra Rai is the registered owner. And Lordship, just page 7, the certificate of registration shows that the vehicle belongs to Subhash Chandra Rai, and he authorized it to. He authorized it to Manoj Rai. Authorization is there. All have been, investigation is still pending. All three persons have been arraigned as accused. The Caesar list and the.
But how did you come to know the name of these persons? From Subhash Rai, you have arrested.
None arrested. Name given by the BSF personnel.
Authorization letter, how did you get?
It was inside the vehicle.
Inside the vehicle?
Inside the vehicle.
That's clearly only Lordship wanted this.
Huh?
From the where was the authorization?
Authorization was, it was inside the vehicle.
My lord, in support of my bail application, I am reading out some portion of the written complaint. Second para, at about 9:20 hours,
one person on scooty coming from Gaurang Bazar towards village Barajora. BSF person, he tried to turn back his scooty abruptly. Seeing this act of suspicious troops, chased him with warning to stop, but he did not stop. Fled away, leaving behind the scooty. I was not on the spot.
You were
That
not
is-
on
that
the
is
spot,
okay.
that is admitted. But the vehicle, you had the authorization letter according to the document which has been seized.
No,
from
no,
the-
I have no authorization letter.
That is your contention, sir.
Here is the authorization.
Nothing has been recovered from my possession, my lord.
Nothing, how
How?
can you are not within the grip till date with the investigating agency?
And
Just tell me, who is this Nando Rai?
He was one of the, he's one of the associate.
How have you assessed him?
From BSF personnel, the 161 statements of the BSF personnel.
So how they know the name of a person? Nobody was there
From villagers.
from villagers.
my lord, whether he has any authorized letter.
Manoj Rai, that is what.
No, not only Manoj Rai, but
You are appearing for Manoj Rai, don't be worried.
Nand
about-
Rai.
You are appearing for Manoj Rai, so let me see the document.
Lordship, page 7.
No, that authorization.
But that authorization is actually the Manoj Rai, the onus still lies on the Manoj Rai because the authorization is not in the format of the RTO. The
No, that's a separate, whatever you are connecting, you are investigating a criminal case. Fine slip to কাটবে না। Is recording the statement of the notary is public, notary.
Recorded the statement of notary. No, investigation is still pending.
What investigation are you doing to? The photostat copy সেটা তো statement নেবে, the original নেই।
Obvious. Lordship, I will record the statement of the notary expert. This is an anticipatory file in the case of NDPS loss.
Our liberty is now becoming very precious, haven't you?
Liberty
seen
is
the
always,
Supreme-
liberty is always precious, Lordship, but
Supreme Court judgment say liberty is very precious. So not of it case for anticipatory.
not a case for it. So, much of.
চলে আসুন। Learned advocate appearing for the petitioner activity. Submits the ad the petitioner has been falsely implicated in connection with the instant case on the basis of statement of the co-accused, and as there has been no recovery from the possession of the petitioner, he may be favored with an order of anticipatory bail. Full-stop state has produced a case diary and a document which reflects that the vehicle /scooty which was seized in connection with his case along with the contraband contained an authorization in the form of notarized document. ওটা একটু photostat copy of করে দেবে, হ্যাঁ, notarized document which reflects the name of the present petitioner being authorized to apply the vehicle. Full stop. How much is the recovery, sir? 97.
97 bottles of codeine phosphate.
Asha. The commercial quantity of codeine phosphate were recovered from the said vehicle. As such,
and as such, and since the investigation is continuing, custodial interrogation of the present petition is warranted aid for the sake of the case. Full stop. Having considered the materials available in the case diary, as well as the fact that investigation is in progress, I am not inclined to grant anticipatory bail to the petitioner. Consequently, CRMA 346 of 2025 is dismissed.
Much obliged.
Yes.
Worship, allegation is under section 85, 117, subsection 2, 64, 62, 109 of the BNS.
Madam,
Worship. The petitioner is the Bhashu.
Accommodation will just now sit in the seat.
Tomorrow come back. Not-
General omnibus, 498.
64 টাকার against it.
It is the Bhashu, but no material is there. 23rd February incident, FIR lodged on.
Calcium. Next.
Madam. Victim informed. So per my instructions, I called the IO. He said there no information given to.
Here, my lord, the complaint is the one at IO, and the victim is my minor wife, but become pregnant. Subsequently, she was admitted to the hospital. At that time, this complaint was lodged. Now, my lord.
No, but you cannot frame out it's a general rule serve upon the victim. If not the victim.
Victim is residing with me.
Huh?
I am the husband of the victim. Victim is residing with me. Your lordship is that, then I'll produce the.
Victim is residing with you.
Yes, madam. I am the husband of the victim. But my minor wife became pregnant, 17 years old. Subsequently, while she was admitted to the hospital, but this FIR has been lodged by the show motor, not by the police. And now one baby was born, child was born, and both of them residing with the petitioner.
Worship, for sake of
Kindly
interest,
see the
one day
one
accommodation, all the victim and the
Kindly see
the baby was born. But there is a two.
Continue with the case, assess, but why should take him in custody?
Yes, kindly see the 164 statement.
I think I take it. 164 is there.
Worship, 164 and confidential. Both are mismatching. One is saying that commit rape and another is worship.
Come tomorrow.
That's why I am.
Come tomorrow, let him assess.
If there is no, then nothing.
If marriage is there.
Yes, madam.
Let him assess. Let him assess.
Yes.
The two statements, my lord, contradictory. One is forcibly raped, another is.
164.
One is a confidential statement of the victim before the magistrate. And another is 164. So another, I have talked with the IO said I have not informed the victim. So this is a POXO case, that's why I am taking one day accommodation. Nothing will be changed.
If it is.
The petition.
But I'm paying for one day accommodation. CD is.
Which police station?
My lord, new NGP, New Jalpaiguri police station.
Not true. কিছুই হচ্ছে না, সব মামলা করছে তাতেই রেখে দিন, তো হবে না। 34 is a relaxation. So what are you going to give?
Your lordship, I leave it to your lordship passes order.
আমি কি order জানি? Give proposals. Lawyers are to apply their minds. Modification. What are you not getting?
Only reduction of the amount, nothing.
Stage of the case.
Stage of the trial not started.
Why are you not starting the trial?
Trial not started.
Anybody absconding?
No, my lord. No, my lord.
Then how many days you are in custody? Only in the custody.
Custody, my lord.
Absconding accused are there.
My lord.
All accused have been arrested.
As per my instruction, now arrested, my lord. I arrested on 2nd November 2024, my lord.
The other accused persons have been arrested.
Now in.
No, my lord. My lord, date fixed for evidence, but no one appeared, my lord. All are in process of law, my lord. No other, my lord.
Anybody any person in on bail?
No, this person on bail, principal in custody, my lord. Charge, my lord.
The brown sugar carry করছে কি আর আসবে কোর্টে আর আসবেই না।
My lord, I am statement of co-accused, my implication.
হ্যাঁ?
My implication, my lord, statement of. Pick up hand. No, এটা না। Delay in trial, man. Resident of Kuchbihar, petitioner, not outside of
So,
the.
I was granting you submit a document of Kuchbihar.
Not landed property, instruction, they have no landed document, proper landed document for this reason, my lord. Any other, proper document means, LR Khotian and the current rent receipt, all this is have to require. If it's landed property, he has to submit the title deed and the Khotian and proper rent receipt. This is the procedure followed before the land trial court, all this not have the proper document, my lord. I spoken to the
So local
only reduction of the amount, 25, 20, total. If he has to submit the NFC 25 has to be cash and the very poor person for this reason, my lord. Since November, my lord, a bail order was passed and languishing, my lord. For this reason, my lord.
Only reduction of the amount will serve your purpose.
My lord, only reduction of the amount, my lord, he will submit.
The local কি NSC নিয়ে নিচ্ছে?
My lord, this is no. NFC will be available. I am honest, man. I am honest. I am honest. NFC is available.
তাহলে কমিয়ে দি কোর্ট নিয়ে নিচ্ছে।
If it is not specifically.
What is the court interpreting this as 225,000?
Yes, madam. Yes, madam. 25 is the registered and 25 is the local, madam.
So 20,000 করে দিচ্ছি 10.
Madam.
The amount of bonds so specified. The petitioner was granted bail. The petitioner was granted bail on 27th of November 2024, but till date, he could not avail the facility of being released on bail because of the amount of bond which has been directed to be furnished by the court learned advocate for the state is present. Next, as for more than 6 months, the petitioner could not furnish the bond. The amount of the bond is modified to the extent that the petitioner would furnish bond of rupees 20,000 with two sureties of rupees 10,000 each, one of whom must be local to the satisfaction of the learned judge, special court, first court, Jalpaiguri. এই পার্টটা সেমিকোলন দিয়ে full stop দিয়ে দেবে. So far as the other conditions are concerned, the same would remain unaltered. Accordingly, CRAN 1 of 2025 is disposed of. কি আছে application?
My lord, I'm for the state on the last occasion, my lord, there was a direction to the petitioner that the present address of the
Who is appearing? Report appearing for the state be kept. Learned advocate appearing for the petitioner, prays for a desire to furnish information of the address where the petitioner stays at Kalimpong. So what is the address? কোথায় গেল?
কোথায় সে কোথায়?
Not today, come tomorrow. আমার চলে শেষ করুন। এটা দেখলি not today. 34 দিন কে পড়েছে? Yes. Who is there? Yeah.
Your Lordship, I appeared for the petitioner. It was that my case. Your Lordship, I complained that no charge sheet was filed. They said that charge sheet has been filed in 2023. Your Lordship has kept it pending for them to bring records that whether charge sheet has been filed or not.
Charge sheet hasn't submitted, you said. Have you got that?
Yes.
I got the full CD. Right. देखिए
The 5 samples matched.
But he has come for Quashing or FIR. Yeah, probably. Is that 26 September charge sheet has been submitted 23. All right.
That is what I got to know from his submission. I have also taken certified copies. I did not get a copy of the charge sheet. Maybe it was not tagged or anything. That's why you didn't get the certified copy. Otherwise,
you come after
I would
receipt
have,
of the copies. You come.
I will do that.
After consideration of charges, you approach this court. Chalo ashun. Petitioner approached the AA's court, challenging the FIR arising out of Matigara Police Station, case number 992 of 2020. However, Mr. Biswas, learned advocate appearing on behalf of the state, has submitted the case diary which reflects that charge sheet has already been submitted on 26th of September 2023. Having considered the change of circumstances, at this stage, there is no scope for interfering with the accusations and or allegations made in the first information report. As such, the revisional application on being CR 169 of 2025 is dismissed. Petitioner would be at liberty to approach the AA's court after the stage of consideration of charges are over.
And we are grateful. Extremely grateful.
These means. Case diary we return to the learned advocate appearing for the state. Chalo. Bolo to ekta সকালবেলা ওটা ভালো হয়নি।
Well, item number 37 will only be not put in. Kind I'm pretty tired.
Yes.
Kind well, first time motion.
First time motion, why do you file?
I prepared.
One day, why do you file?
Tomorrow. Kindly tomorrow.
Why tomorrow? Next week,
no, kindly tomorrow.
Serve. স্যার সামনের সপ্তাহে পুরোই শুনে নেবো কেস ডায়েরি আমি দেখে নেবো আবার কি আছে মামলায় কিছু নেই 307 injuries you are the
302 matter my lord 302
that you say 302 they give charge sheet on 307
I was murdered my lord. Now my daughter was murdered, subsequently police charge sheeted and the witness.
So why are you taking time, sir? No expertise order can be passed. You are not wanting stay.
Tomorrow. I could not prepare today.
আরে প্রিপারেশন কোনো জায়গায় নেই সার্ভিস ছাড়া কোনো অর্ডার হতে পারবে না
I can serve my lord. By
you serve upon the state as well as upon the private next circuit করে দিচ্ছি আবার কি হবে ম্যাটার you are de facto complainant.
But stay must be given otherwise the process.
So let them proceed, sir. No. Addition of charges can be done at any stage, sir.
That
বুঝতে পারছি না de facto complaint is stay চাইছে মামলাটা নষ্ট হয়ে যাবে
otherwise with the allegation 302 my lord, the police authority intentionally my lord, allegation of the 307
I understand that, but then you tell me one thing, stay is better or scope of addition of sections at the subsequent stage is better. So why are you wanting stay in this case as a de facto complainant?
Allow me to serve, I'm calm.
তাহলে শুধু টাইম নিয়ে কি হবে?
Monday,
মানডের মধ্যে হবে না।
I copy to serve state.
And there are other persons you will be adding, they won't be prejudiced, they will not have an audience.
Yes, sir.
Petitioner is directed, এর বেশি তো order হবে না, বেকার এই করে, there is no scope of stay in this matter, sir. Stay will spoil your case, you are the de facto.
Otherwise, the prosecution will start.
And let the prosecution go on, sir, addition of section can be done at any stage.
But that line may be added, Miller.
আরে দেখো।
That will
না তারপর পরের দিনে ওখানে গিয়ে অ্যাপ্লিকেশন করে অ্যাড করে দাও বলে দেবে।
302 must be there, Miller.
I understand, but see one thing, the accused persons are facing, they must be having an audience before this court.
Definitely before lordship. The witnesses, Miller, the witnesses, they are.
You are the witness, our witness.
No, Miller, the witness myself and the rest of the witness are the family members of the Miller principal accused.
সেটা দেখতে হবে তো। But you are PW1 too.
I am only PW1 person is given, Miller. My
ঠিক আছে PW1 কোর্টে না গেলে তো আর সাক্ষী হবে না।
Yes, sir.
Everything is within your hand. Why are you wanting a stay? Petitioner is directed to serve a copy of the revisional application upon what office of the public prosecutor or what? Upon the office of the additional public prosecutor, High Court of Calcutta at Circuit Bench Jalpaiguri, your formatted and also upon the opposite party numbers 2 to 5 by speed post with and file affidavit of service on the next date fixed hearing. List the writ petition, list the revisional application under the heading contested application in the next available circuit bench. Cholo. এর বেশি কিছু order, state would produce a case diary on the next day, it's so fixed.
Yes, sir.
Is appearing for the first time, my lordship.
Yes.
I am the principal and my lord,
Hey,
teacher and the governing body of the
stay of the investigation. I've seen that. Learned Mr. Michel, learned advocate appearing on behalf of the petitioners. Challenge is the continuation of Pondibadi Police Station case number 372 of 2025. Learned advocate refers to the application under section 175(3) of the BNSS, also wherein according to the petitioners, the preliminary grievance, if accepted to be true, is breach of an agreement.
They have also filed before the DLS for compromise of the contract and tender and everything.
I have say observe, this is only at the initial stage.
My lordship.
Stop. I have considered the accusations made in the FIR along with the application under section 175(3) of the BNSS yellow. Petitioner is directed to serve a copy of the revisional application upon petitioners are directed to serve copy of the revisional application upon the opposite party number 1 through the office of the public APP High Court Calcutta, Circuit Bench Jalpaiguri, and upon the opposite party number 2 by speed post with AD and file affidavit of service on the next date fixed for hearing. List the revisional application under the heading contested application. After 6 weeks. In the meantime, the investigational proceedings of Pondibadi Police Station case number 372 of 2025 dated 23/4/2025 is stayed for a period of 8 weeks from this.
I'm deep.
My lord, I beg to appear on behalf of the petitioner, my lord. My lord, this is a case which was registered in the year.
On what grounds are you wanting quashing?
Actually,
18 years elapsed from the date of institution of the case. Only 2 witnesses have been examined so far. Even the de facto complaint has not been examined for last 18 years, sir.
So then you have got to give whole of the order sheets, sir.
All the order sheets are there, Lordship.
Where are they, sir? From 2007 onwards, all the order sheets must.
All the order sheets are there, Lordship.
Where?
Order sheets. Already there. It's already,
From 2007 onwards, where are the order sheets?
This is a certificate copy, Lordship. I just apologize, Lordship. I have not annexed perhaps. All the certificate copies are there.
File a supplementary affidavits. Petitioner is directed
Lordship,
to.
keeping on Monday, Lordship. Tuesday.
You have no case, sir. After evidence commencing, nothing is there.
Lordship, at least speedy disposal, Lordship, that order can be passed, Lordship.
That I can pass.
Lordship.
Full appear. I'll dispose of them. Learned advocate appearing for the petitioner it's that the present case being Kotwali PS case number 508 of 2007 dated 8/9/2007 has been pending for about 18 years and the petitioners have been attending the courts. It has further been submitted that only 2 witnesses have been examined out of the
7 witnesses.
7 witnesses so cited by the prosecution. Having although the petitioner prayed for quashing of the proceedings, but has restricted the submissions before the court for expedited progress of the trial.
Video stop.
Limited submissions and prayers so advanced. Petitioner is directed to serve a copy of the revisional application upon.
I've already served the copy, Lordship.
Upon Mr. Niloy Chakraborty, learned advocate who ordinarily appears on behalf of the state. Revisional applications are you develop the culture, motion is never served.
Lordship.
Writ petition is served.
Lordship.
Civil revision served, but then criminal motion, it must be expertise. That advantage is with the court. If the court feels or otherwise something, because criminal division, there is a specific provision. The court can decide even without hearing anybody.
Lordship.
কি বললাম ওই অ্যাপয়েন্টমেন্ট রেগুলারাইজ করে চলে দিন হ্যাঁ আচ্ছা in view of the proceedings pending for about 18 years I direct the learned judicial magistrate first court Jalpaiguri to fix at least 1 date in a month on and from the next day so fixed.
Next date has already fixed on 9/1/2026, Lordship. After 1 year, date has been fixed.
1 year from this. কি বললাম in each and every month. Learned trial court would prepare on the date so fixed in the month of January 2026 and fix a schedule having considered the period of anxiety and agony faced by the petitioners for the systematic delay which has already occasioned. Would stop. The learned magistrate would prepone and fix the next date in the month of August 2025 and ensure that the judgment end of the case is delivered after at least providing adequate opportunity to each and every witness cited by the prosecution.
In this case, most interestingly,
on or before 31st of December 2026.
In this case, most interestingly, de facto complaint has not been examined, but the IO has already been examined.
Up to 31st December 2026, I have asked to deliver the judgment.
Grateful, deeply grateful, Lordship.
With the aforesaid observation, CRR 252 of 2025 is disposed of. 39 পর্যন্ত হলো নাকি? Forty আছে কেউ করবে? You will do or after recess you will do?
Hello.
Come after recess. If nobody appears, I'll dispose of them.
Yes. Hello.
Come after recess, everybody.
I am for the petitioner. I am for the petitioner, my lord. I am for the petitioner. You video stop. Hello. I am audible. Am I audible? Video stop. Video. I am. I am for the petitioner, my lord. I am audible. কেটে গেল নাকি? আমাদের ছবি আসতে হচ্ছে কোথায় হচ্ছে কেন হচ্ছে am I audible? কেটে দিয়েছো লাইভ কোথায় রাখেন টিফিন টাইম আচ্ছা টিফিন চল টিফিন নেমে গেল না ও খেতে চলে গেছে লাইভ স্ট্রিম পজ করে গেছে লাইভ স্ট্রিম পজ আছে ওদেরটা বন্ধু উঠে গেছে উঠে গেছে এই জন্য পজ করে দিয়েছি চলো কেটে লিভ করেন লিভ না আমার Video stop হয়ে গেল। বলো। আইটেম নাম্বার শুনতে পাচ্ছি না। কোনটাই খুলছে না। কি কাণ্ড লাইভ মিউট তো কালার করে কেন করে? ও বলে পজ করে রেখেছে। এটা উপর দিয়ে নাও পজ মিউটেড। না না ওখানে তো খুলবে স্যার। ঠিক আছে আপনি এটাতে কথা হবে এটা বড় করে দিই মেরে দেখতে হবে। থাকলে যাবেন দাঁড়িয়ে ফোন করে যাচ্ছে নিশ্চিত এটা কেন আছে সবাই লাইনে আছে আতরণ কাজ বেশি করেছি थोड़ी আমরা আপনার পুলিশ রিমান্ডে নিল আমরা কিন্তু পছন্দ না ওয়ান জিরো সিক্স আজকে বেশি কেস আমার ছবিটা ছিল
কি আছে দেখি
ছবিটা দেখে না
এগুলো এসছে কিভাবে মেনশন করেছে নাকি হ্যাঁ ডিপার্টমেন্ট থেকে
তোমার তো ধর ছবি আসতে গেল
ইউ আর appearing
Sir.
All right.
Oh.
Where are you state council? Where is the affidavit of service, sir?
Yes,
Huh?
matter number 40.
Yes.
Yes, sir, I am, Milord, I am moving on behalf of the petitioner in this case. But I am not ready to place the case before your honor because I have came back today after summer vacation. Kindly please make an accommodation for 2 days.
All right, do it tomorrow.
No, I am from 250 kilometers away. Day after tomorrow. Milord, day after tomorrow.
You are carrying on the profession. This is not a retirement job.
Please.
Profession is a regular job. The courts are open, the schedules are there, the calendars are published at the inception of the year. You cannot have a schedule differently.
Milord, I am for the de facto complaint. Day after tomorrow, please.
This pleas and kindness is spoiling the courts.
Oh.
কিছু নেই মামলাতে একটা অ্যাডমিশন করে নিয়ে বসে আছে you are appearing you've got the case diary already day after tomorrow date দিয়ে দিন date দিয়ে রেখে দিন
So blessed, Milord.
মামলা ফাইল করে দিয়ে বাইরে বেড়াতে চলে যান yes 41 who is appearing new matter, fresh matter, people will file and forget. কি আছে এখানটা? Evidence over. Mr. Chakraborty, you appear in this matter at a Xerox করে ওনাকে দিয়ে দেবেন তো। I think arguments are over in this case. This is what is reflected from the order sheets. 25th of April 2025 for argument it was fixed. Basically useless, but since nobody is assisting, একটা order নিয়ে নিন। As none appears on behalf of the petitioner, but the records of the case reflect that arguments were fixed on 25th of April 2025. Accordingly, Mr. Niloy Chakraborty, learned aid advocate who ordinarily appears on behalf of the state, is directed to represent the state. His appearance will be regularized by the concerned authorities. Learned advocate aid for the state will submit a report before this court in relation to the present end stage of Bokshirat PS case number 40 of 2012 bracket GR 108 of 2012 on Tuesday, possible by Bokshirat by Tuesday.
But today I have required the copy of.
On 17th of June 2025, when the revisional application will appear under the same heading. Next.
For the petition.
Yes, please. First time appearing.
First time appearing.
First time. You're having a great problem in your matrimonial life. Huh?
Well, if you show Lordship kindly sees the report, my lord, it talks nothing about the stolen articles.
175 rejected. So without hearing, nothing can be done. Petitioner is directed A to serve copy of the revisional application on the opposite party number 1. What, through the office or what? To the office of the additional public prosecutor, High Court, Calcutta Circuit Bench, Jalpaiguri, and upon the opposite party numbers 2 to 7 by speed post with AD and file affidavit of service on the next date fixed for hearing. List the revisional application under the heading contested application in the next available circuit bench. তো ওকে দিয়ে দেবে না জুনিয়র দিয়ে দেবে entitled না না কপি একজনকে দেবেন নেক্সট
For the petition. My lord.
charge sheet submitted.
Yes, my lord. Charge sheet submitted, my lord. My lord, this is a case of 376 and medical decline, my lord. My lord, kindly see page number 14.
এগুলো একটু খুলে
Fourth
দিন না।
line, my lord.
এগুলো বার করা যাচ্ছে না পুরো সেলাই করে দিয়েছে দেখুন তো ভেতরে কাগজগুলো বার করা যাচ্ছে ঠিক আছে yes
My lord, page 14. My lord.
madam you have stitched everything
My lord, my clerk.
এটা তো এফআইআর 14 বলছে 14টা তো এটা পুরো স্টিচ করা আছে
My lord, I think certified copy also.
you have stitched that along with the
Oh.
just wait for some time I'll pass over এটা এগুলোকে একটু কাটিয়ে দিই করে করে নেক্সট ম্যাটারটা ডেকে দিন কাউকে
My lord, I am for the petitioner, my lord, in this matter, my lord. I've come for the first time, my lord, regarding quashing of FIR, my lord. Allegation against me is, my lord, I organize illegal assembly and abuse to the public, my lord. That I am a social activist and also a lawyer, my lord. And for the tea garden workers, my lord, I had given later, I sought permission from the concerned authority, SDN, municipal chairman, Darjeeling, my lord. But despite giving the letter, my lord, they didn't supply me the or provide me the permission, my lord. And but I said for the dharna for the rights of the tea workers, my lord. Against that, my lord, police filed this applicable this FIR.
So then you should have filed police in action or inaction
No,
for
my
not
lord.
granting permission, but you violated the order.
No, actually, they didn't give me, lord.
They didn't give the it lies against that.
My lord, kindly issue the notice, my lord. Let this CDM maybe call for my lord.
Exams were there. That
No,
is why.
there is. It was on holiday, my lord. Saturday and Sunday, my lord.
The exams were there, sir.
No, but my lord, there is judgment of the principal bench, coordinate bench of the this High Court, my lord. On the holiday, my lord, this High Court had given permission to the Vishwa Hindu Parishad to organize rally, my lord. Is stating that that is a holiday, my lord. In the same manner, my lord, who have sought the permission before the authority concerned, instead of replying.
The High Court granted permission.
Yes, my lord.
You didn't have permission.
No, actually, we had
So you thought that you can do anything.
No, my lord. Actually, it was peaceful dharna only, my lord.
That is your contention.
My lord.
Question, a disputed question of.
May I be permitted to send the?
No, this is continuing over there. You seek permission from the High Court.
My lord.
And you do that. Suppose administration refuses, sits tight on the issue. Within a close proximity of time, if you think your rights are violated, then you have got to file an application, sir.
And it is a FIR this with the malafide intention, my lord, filed by the police.
That is a separate
And
issue.
there is no this concrete allegation against me also, my lord. Their allegation is I said for the dharna without any permission, my lord. And that is my democratic right, my lord.
Without permission, if you think you have a democratic right.
And there was no 140 prohibitory order also, my lord, in the Chaurasta, my lord.
Sir, where did you sit?
Chaurasta, Darjeeling, Chaurasta, my lord.
The Chaurasta is a public road.
Public place, my lord.
The public place, how can you say reasonable restrictions are not there?
No, there is no restriction, my lord.
Reasonable restrictions.
There is no
public place is reasonable restrictions. I'm not saying restriction.
Lord.
Restriction to emergency. Reasonable restriction. So you go through those judgments of Amit Sahani.
Milord.
Binu Raut, what are the rights? Rights are there. Definitely you have a right. But that should not disturb the public at large.
No, and this issue is very pertinent issue, Milord. That
No, that's your
So
party.
this is for the right of the poor tea workers, Milord, who didn't get the bonus, Milord, during the puja, Milord. And government intend to give those tea garden lands to the
So
industry.
there are thousands of reasons. I am not into democratic rights. You have a right to protest. But right to protest, you have sought for permission. Permission either was not granted or they kept sat tight over the issue. Then you have got to move the High Court for getting the permission. You cannot show a High Court order granting permission and apply in this case because you did not apply to the High Court.
But on the that issue of examination, Milord, they didn't issue me the permission, Milord.
That is
kindly allow me to solve the copy, Milord. Let this be hearing, Milord, in this matter, Milord.
Not let come after submission of charge sheet, not at the FIR stage. After submission of charge sheet, we'll consider.
And even notice is not issued to the accused also till date, Milord, 35-3 in this allegation.
So you are unnecessarily inviting problems. It was lying silently.
Milord.
Chalo dispose of করে দিন।
Milord, kindly allow
না
me
না
to issue them.
come after submission of charge sheet. Petitioner is directed to serve copy of the revisional application upon Mr. Obhijit Sarkar, na? Mr. Obhijit Sarkar, learned advocate who ordinarily appears on behalf of the state. His appearance may be regularized by the concerned authorities. Learned advocate appearing for the petitioner has drawn the attention of the FIR being Darjeeling Shodor Police Station case number 25/2025 dated 8/2/2025. Wherein learned advocate submits that as permission was not granted, even after addressing to the concerned authorities, the petitioner had to sit in protest. Full stop. The police authority is malafidely instituted the FIR out of private and personal out of grudge, out of grudge, and the same is not maintainable in the eye of law. Full stop. I have considered the FIR being registered on the basis of an information furnished by one sub-inspector of police attached to Shodor Police Station in Darjeeling. And I find that the reasons were assigned were in respect of examinations which were supposed to be held for disruption of public order and peace and formation of unlawful assembly along with other reasons. Full stop. Having considered that the investigation of the case is in progress, the issues so canvassed by the petitioner relate to disputed question of facts which cannot be adjudicated at the stage of investigation. Petitioner would be at liberty to approach the court after the report under section 193 BNSS is submitted by the investigating authorities. Full stop. With the aforesaid observations, CRR 230 of 2025 is disposed of.
Obligement.
Next. একটু এই পাতাটা শেষ করে নিই তারপরে
I am for the state, my lord.
Investigation going on, charge sheet filing. Charge sheet has not been submitted yet.
Petitioner number 1 is the mother-in-law and petitioner number 2 is the sister-in-law.
Where is the FIR?
Lordship, so last original certified copy is annexed, Lordship.
May I hand up this seat?
He totally, he stopped contacting my mother, going to keep me. Twenty-three case, why not? What is the problem, sir? Charge sheet not submitted by? From,
It was filed in 28 February 2024, my lord.
huh?
Copy was served on 28 February 2024, my lord.
Copy, no.
After that,
Why not?
I have a duplicate CD, my lord. I have to inquire.
That you submit, why? 23 case charge sheet must be submitted.
My lord, half an hour time maybe.
No, no, half an hour, কালকে আসলেই হবে।
My lord.
Come tomorrow, let me see what is the progress of.
Lords.
এটা not today করে দিন। অর্ডার দেবো? অর্ডার লাগবে?
লাভ হবে না।
হ্যাঁ?
লাভ হবে না।
Not today, it will be there in the list, retaining its positions.
দেবে না? Appearance দেবে না? Disposal না হলে নেই।
46 who is appearing?
Lordship. Copy লাগতো? দিয়ে দেবো। Deepak, this Lordship, in this matter, all the petitioners, they are the in-laws. In-laws rather distant relations out of that.
Well, there was an interim order earlier.
Earlier interim order is there.
The interim order is still there.
It's right.
No, no, there is a CRAN over here, that's why I'm asking.
Yes, CRAN is there and the service is already been completed.
Huh?
Service is also already completed. Regarding that.
So what is the till final disposal? You have an interim order? Okay. It appears to me that. Eight weeks. কবে অর্ডার দিয়েছে? 30th September. 6 মাস stay নেই। What is the stage of the case? Stage of the case, sir?
Stage of the case, charge sheet has already been filed by the investigating agency.
Alright, since an interim order was there, who is appearing for the state? You are appearing?
Well,
Produce, you got the case diary?
no, my lord, actually, I missed the brief. Yeah, I'm unable to locate the brief. I'm asking for a copy of the brief.
Alright, produce a case diary.
Day after tomorrow, my lord?
Day after. একদিনে এক একটা করে দেবো।
না না কালকেই আসেন আমি আবার একটার জন্য
Day after tomorrow.
Lordship, in the one in the previous matter that may be fixed also day after tomorrow.
No issue.
If it is possible. No,
ডেটটা ওখানে লিখে দিন না একটু আগের মামলাটায়।
আমি পুরো এন্টারটা দিয়ে দিচ্ছি তোমাকে আমি মামলাটা দিয়ে দিচ্ছি তোমাকে ওকে
ওইটা একটা অর্ডার করে, এটা অর্ডার লাগবে তো, সিডি আনাতে হবে। সিডিতে আছে। হ্যাঁ?
ডিসপোজাল না হলে কিছু নাই।
এই শুধু
পাঠাবো কেটে দেবে।
শুধু না না বলো না তো।
পাঠাবো কেটে দেবে।
The petitioner, learned advocate for the petitioner has challenged the continuance of the proceedings. Mr. Viswas appears on behalf of the state. He is directed to produce the case diary of Pradhan Nagar or PS case number 425/24 dated 3/7/2024. As we lagben. Leads the revisional application on 13th of June 2025 under the same heading. So next. 47. Yes, Mr. Bomi.
My lord, I have paid for the order, the quashing of the order dated 3rd October 2024. That the proclamation was issued without receiving the non-execution report of warrant of arrest.
In what case?
My lord, this is a 14A and 14C of the Foreigners Act. I am Indian citizen.
Oh, yesterday you.
My lord. Lordship, order dated 22/8/2024 clearly reveals that non-execution report is produced. NER is produced. At first, it due to typographical error, maybe it was written that no year of WA is received, but in the subsequent line, it has been stated that NER is produced. That is the running page number 17 of the application of my. No, that may be typo, but kindly see the order dated 3rd October 2024. No, order dated 22/8/2024 clearly reveals NER has been received. My humble submission before your lordship. And it's a case of, it's a case of Foreigners Act, lordship, and absconding for a long time, and unless proclamation can be issued, in that case, the trial court could not actually separate the file also.
The proclamation has been issued already.
Yes, on 3/10/2024.
3/10/2024.
And 22/8/2024, NER non-execution report has been produced. But
has he been declared proclaimed offender?
No, but WPA is issued.
Come to 3/10/2024.
After 3/10/24, 30 days time will be there.
And that has gone too.
That's gone.
That's why I'm asking you.
No, lordship, actually, that page has not been annexed. Not been declared. That order has not
The
been
time was granted to seek instructions.
Not been declared, not been declared. One day.
Come tomorrow with Papa. Why?
Yesterday also your time. Yesterday I was not there. Yesterday I was not there, my friend was.
3/10/2024 is 6 months, more than 6 months.
Yes, actually, after 30 days, the court shall declare it.
So 30 days have passed.
30 days have passed.
Huh? What is police doing? I'm giving you 2 days time. 13th I'm keeping. Come with a report.
On
13th.
13th.
Come with a report.
Come with a report.
Stage of the case must be specified.
Stage of the case must be specified.
Along with the fate of the order dated 3/10/2024. তো কোনো কাজ করে না, বসে থাকে সব পুলিশগুলো। আমরা পারছি না কাজ করতে, স্টাফ কম সব জায়গায় বলবো। আচ্ছা,
Fate of the order.
ওই state is directed to submit a report on 13th June 2025, which would incorporate the stage of the case as well as explain regarding the steps taken pursuant to the order dated 3/10/2024 passed by the learned CJM Jalpaiguri. List the revisional application on 13th of June 2025.
Much of best. Get for your house.
Same meaning. এই মামলাগুলো 2 মিনিটে মামলা 2 মিনিট। তাই তো প্রোক্লেমেশনটা স্টে করে দিলেই আপনি নিশ্চিন্ত তো অ্যান্টিসিপেটরিতে চলে যাবেন।
That is my humble contention before your lordship.
48, my lord. Maybe your lordship. But I am for the petitioner.
I am appearing for the opposite party, lordship.
Opposite party?
You have challenge the order of the revisional court. It's the second time, my lord. Previously, I filed but the learned magistrate order, there's a proceeding under 140, 107 and 145. The petitioner has been dispossessed from the land, pursuant to the land executive magistrate. The dispute related to the land. And the opposite party, number 2, my lord, relying on the record of right, that he claimed he has been dispossessed by my client from the subject land. At the moment we came to know that his name has been recorded with regard to the subject land, though we are the owner, we made a complaint to the bureau of concern also. That is still pending. Then I filed a revision application, and when I challenged that order before this honorable court, my lord, then if you also kindly see, there is an order of coordinate bench. The order of coordinate bench will refer the matter, but that is page 28. Page 28.
You have received full copy. What are you wanting? You tell me, sir. Yes, yes.
Oh, yes, sir. May I proceed, my lord? May I proceed?
Yes, yes, you continue.
Yes, yes. Then, my lord, your lordship, that is the start from page 28. There's a coordinated bench decision. His lordship my lord refer the matter. Then, my lord, page 30, my lord, relevant page, my lord, page 36, paragraph 9. Page 36.
Yes.
But that prior to that, the order of the learned revision court was quoted. Then from the above observation, the learned session judge, it appears that the points raised by the appellant were not at all considered by the learned judge for the reason best known to him. It is the duty of the learned judge to consider the relevant points of facts and law which are raised by the learned counsel by the parties in the course of hearing, without dealing with the such factual and legal issues involved in the relevant matter. The learned judge has passed the impugned order dated 17 September 2022 in a slipshod manner, which is not desirable from a judge holding the chair of additional district and session judge. Therefore, I find merits the submission learned counsel of the appellant that the contents of the appellant were not at all duly considered by the learned additional session judge, and thereby gave error has been done in justicing the cause of the present appellant. For the sake of justice, it would be better to ask the concerned court of the learned additional district session judge such and such to pass a rescinded order afresh on the division application being number such and such filed by the present appellant before the said court after hearing the parties and to pass appropriate order covering all points of factual and legal aspect raised by learned counsel of the parties in a time in the bound manner in the instant division allowed. Then, my lord, that was allowed. And next page, my lord, line number 3 from the top, the division application is pass an appropriate order afresh on the criminal division application after hearing all the concerned parties within 2 months from the date of receipt of this order without being influenced by any of the observation in the judgment. The present position of the respondent number 2, that would be 2, over the land in question shall be subject to the decision of the criminal division of the such and such. Like admittedly, my client has been dispossessed.
18th September.
But related to the land, total manner, this.
Where is the magistrate's order? Where is the magistrate's order?
Oh, yeah. Oh, yeah,
18th
yes.
September.
Magistrate order, my lord. Page 21. Order of magistrate, page 22.
Page?
Page 22, my lord. 22, if I'm not wrong.
22 is something different, sir.
No. 22 is the order of dated 20th 11 2019.
This is the first order which was challenged by the petitioner.
Where is the order which you have challenged before the learned?
Learned magistrate. You
challenged the magistrate's order before the revisional court, na?
Yes.
Where is that order?
Oh, that order is with me also. That is not with the petitioner. I'm sorry, my lord.
So without that, how is it possible to decide, sir?
Then I have to file a supplementary affidavit. That order is
So
with
file
me
a
also.
supplementary affidavit.
I am, yes, I'm extremely sorry, my lord. I'm tendering my apology.
Learned Advocate 8 appearing for the petitioner is directed to file a supplementary affidavit incorporating the order of the learned
22nd June 22.
27th June 2022, which
Yes.
was passed by the learned executive magistrate Tufanganj.
Yes, yes,
Impugned
yes.
order also,
Petition that is 18th of
September 20.
which is the impugned in this revisional application according to the petitioner lordship. That has also been.
This order is of which date?
That is 18th of
September
2024.
Ah.
September 24.
Revisional
Ah,
application.
ah.
Also not annexed in my petition as well as.
No, that is annexed over here, sir.
That is page 35. But April
No,
also
that
said this.
certified copy is there. That certified copy, 18th September 2024 copy.
But in our copy, there is not any.
Send a copy to the learned advocate for the
yes,
state
yes.
as the opposite party. 18th September 2024 order. In my
Yes,
copy
yes,
it is
yes,
there.
yes, yes.
In their copy it is not there.
Oh, yes.
That
yes,
you
yes,
send
yes.
a copy to them, sir.
I shall-
So
I
as
shall send
a
it.
supplementary affidavit is concerned, you file the executive magistrate's order, which was the
Yes.
genesis of your revisional application.
Yes. It has been quoted in the order of other coordinate been page 35. That has been quoted. I know it.
So very good that how
Yes,
can
yes.
you file that without a complete one?
Yes, yes. Without file supplement, I can.
Let him first file the supplement. আচ্ছা তাহলে দিয়ে দিচ্ছে
Yes, yes, yes.
it's wait, how much time?
Well, because which times I mean, it is required, but I'm here. I have to contact with my client also.
How much time you tell me?
But 2 weeks time is necessary. But next Saturday.
30th June by 30th June?
Yes, 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 yes. 30th June.
Let's a supplementary affidavit be filed by 30th June 2025. If the petitioner and the state intends to use affidavit in opposition to the revisional application as well as the supplementary affidavit proposed to be filed by the petitioner, the say aim be filed 3 weeks, madam.
Yes.
By 21st of July 2025, affidavit in reply, if any, be filed by 4th of August 2025. List the revisional application in the first week of August before the available circuit page in the first week of August 2025.
Yes, madam.
Impugned order also.
I have unconsidered, madam.
I have requested him, sir, if the order is available.
Yes, yes, yes. I shall hand over.
In.
Yes, I'll get over.
কত 40 এখন কি হবে?
Get from chamber.
Who is your other side?
No, this is the first time this matter is being.
First time.
My lord, I'm praying for stay of a warrant of arrest. My lord, the petitioner, my lord, he was arrested in 2022, my lord. My lord, thereafter, subsequently on 19/4/2023, he was granted interim bail by the trial court. My lord, on one particular date, my lord, that is the impugned order, my lord, on 5th of October 2024. My lord, because of the mistake on the part of the learned lawyer, my lord, he was standing outside the court. He did not enter the court on time. And when they appeared at 12 in the noon, a warrant of arrest was issued, my lord. My lord, he was on interim bail, my lord, all along. And my lord, the trial has also commenced. My lord, out of 9 witnesses, my lord, as per my instructions go, my lord, 6 have been examined already. My lord, page 46.
You have delayed the trial.
But the trial, but my lord, just 2 witnesses are left, my lord.
I left, but then at the strategic moment you have done this.
My lord, this was simply because of a miscommunication between the learned advocate for the trial court and the petitioner, my lord. My lord, he was right outside the courtroom because, my lord, on the previous date.
Miscommunication or well advised?
No, my lord. No, he was inside the courtroom because his advocate was not there, my lord. It was not considered. It turned up late at 12 o'clock. It was not accepted. My lord, the next page is, my lord, page 47 is the previous day's orders, my lord. I have appeared on that date as well.
You are the sole accused person?
Yes, my lord.
When were you granted bail?
My lord, I was granted bail on 19th of April 2023, my lord, in the
Interim
page
bill.
38. Yes,
Your
my lord.
Interim bill.
Yes, my lord. And my lord, that was being extended from time to time. My lord, page 38 is the order, my lord.
5th of October, you were absent.
Yes, my lord. My lord, I was present in court, my lord. There was no representation because
I
of that.
don't know. Anyway. You go. I am directing and comply with the order. I am keeping the you appear by Monday.
My lord.
You will continue on the same bill and bond.
Great.
All right, and I am keeping this matter on Tuesday.
My lord.
All right, take instructions whether he has appeared or not.
Right.
So, petitioner is directed to serve a copy of the revisional application.
Yes. So on the office, my lord.
Upon Mr. Ganguly, learned aid advocate 8, who ordinarily appears on behalf of the state, his appearance may be regularized by the concerned authorities. Are learned advocate appearing for the petitioner submits that the petitioner is very and willing to appear before the court, and while on interim bail, he had been very he had been regularly appearing, but accidentally he could not be physically present. Accidentally he reached late, and consequently warrant of arrest has been issued. Petitioner petitioner as such apprehends that in case he appears before the trial court, he may be taken to custody. Full stop. In view of the records which are being placed before the court, I direct the petitioner to appear before the learned additional sessions judge.
First court NDPS.
NDPS where?
Lord, this is police station is Shahipur, my lord, so it will be Kuch Bihar.
No, NDPS Kuch Bihar.
Kuch Bihar, my lord.
NDPS is Kuch Bihar. Kolam. Last sitting. Taragi in view of the above. To appear before the NDPS court by 16th of June 2025. In case the petitioner appears before the learned special court
Additional sessions judge.
within the aforesaid time period fixed, the learned aid additional sessions judge first court NDPS Act Kuch Bihar would allow the petitioner to continue on the same bail and bond which was earlier furnished by him in connection with NDPS case number 81/2022 on such terms and conditions as he deems fit and proper. Full stop. The revisional application will appear under the heading to be mentioned on 17th of June 2025 when the learned aid advocate for the state would submit a report from the public prosecutor appearing in this case before the learned aid special court. আর তো কিছু দরকার নেই, একটু হলেই তো হয়ে গেল, বেকার দেরি করে লাভ নেই।
Great.
কি আছে? You are appearing? 50. Is what is there?
Lordship, initially, on the basis of this complaint, the case has been started under section 126, 115, 303, 324, 351 of BNS. After the investigation, the charge sheet has been filed only.
341, 506.
Yes. Initially, case has been started against the own brother of the defector complainant.
তো সে তো ঠিক আছে। Where are the statement of the witnesses? তো ওগুলো অ্যাডমিশন করে দিয়ে আমার বিপদে ফেলে দেয়।
certified copy of the charge sheet is annexed. Lordship.
From charge sheet, what can a person understand, sir? You are accused in 341, 506. So whether wrongful confinement is there or not, on the basis of the statement of the investigating officer, I will decide what is true and what is false. Okay. পাঁচটা সাক্ষী আছে তো। At least 3 witnesses are there. Alright, produce a case diary.
Lordship.
এটা আমি করতে চাই না একদম, this is a bad culture. State is directed A to produce a case diary of Shiliguri PS case number 997/24 on 17th of June 2025. When the revisional application will appear under the same heading.
Lordship, like CRAN application may be disposed of at the same time. Already CRAN application is there.
CRAN for what?
Stay was granted.
Stay was granted on the very first day.
17th of June too. When is your next date?
In the lower court.
Huh?
Due to the stay, I am not appearing before the court below.
If warrant is issued, you will face the consequence.
That stay order may be extended.
Stay, I don't know, you have got to give me the last order. Otherwise, why are you bothered? If there is no interim order, if there is no interim order, I'm fixing the matter on 17th only.
17th.
Next সাথে then.
I'm for the statement.
কি আছে? Who is appearing in 51?
Lordship. The case has been started under section 153A, 295A, 505(2) of IPC.
কেন কি গালাগালি দিয়েছে?
Lordship, so nothing. The allegation is that.
Charge sheet submitted?
Yes, Lordship.
Submitted.
Where is the charge sheet?
Only charge sheet is annexed.
Charge sheet is annexed?
Yes, Lordship.
My lord, I'm holding the seat, Lordship. Certified copy of the seat.
You have got that?
Yes, Lordship.
How many witnesses are there?
Worships 9.
9 number of witnesses are there.
Publication made where? Facebook?
Facebook, my Facebook,
Huh?
Facebook ID.
So how have you retrieved that from the Facebook?
Lordships, that was seized by the mobile and others report also they have collected. That lady, yes, Lordship.
Let me see.
They have stating that the Kurban is a permission to Parpa Tarpa in writing in the Hindi, Your Lordship, in the language, Lordship.
I want to see the expert reports, how they have collected.
Silver color. 46 GB containing all the original evidence of collected from the Facebook, social media platform, my lord.
That's Caesar too?
Yes, Lord.
So you have sent it, how are you going to prove that Caesar, sir? Where is the expert opinion you have sought for?
No, no, sir, the charge sheet has been filed. Facebook ID and the agency printed the mobile, this will put this linked mobile number, such as email address. As well, so from being asked the producer Samsung Galaxy such and such. Community suggest When I see this development, and then the SD card, post cover, envelope, and 2 pages of hash calculations for landed ACGM code.
SDF has submitted a report.
Observations. I sent No, my lord. Report not here. Expert opinion not here.
Expert, have you said?
No.
Huh?
Said. Expert said.
So bring that, sir. No, bring that report, produce that report.
Lord.
Now, কি করে decide করবে এইসব মামলা? Or when? Have you received or you is there report from the Salt Lake SDLP sector 5? Have you received that from there?
No reflection, my lord. In the CD, there is no reflection, only
কি
CD.
করে মামলা হবে তাহলে? That's the main substance.
Substance.
Alright, next Thursday, I'm keeping the matter. In the meantime, you just assess whether you received. On many occasions, what happens, you know, you are from far off place, at least from sector 5, they send it directly to the ACGM.
ACGM, my lord.
Huh. So it may be in the lower court records also. Huh. And if it is not there in the lower court records, then you have got to collect it from there. Inform me what is there, sir. কি করে করবো এইসব মামলা না?
For LC.
হ্যাঁ?
Maybe.
না, it's another event. এমনি হয়ে যাবে।
My lord, what direction to IO whether they have collected from the
I will require the report.
lordships.
Expert opinion, because Facebook,
Yes, lordship.
without expert opinion,
It is very difficult to assess.
এই কেসেই কিছু থাকবে না।
Obvious.
161, on 161, these cases cannot be proved, na?
Yes, lordship.
Thereafter, I will assess regarding the merits of the contention. Whether the merits make out any case or not. But at least the investigation must be in a format required in this type of cases. So that's আজকে কি বার?
2 days.
By next Thursday, enough time, sir?
Lordship.
Huh? Enough time?
Lordship.
You complete everything, check if it is available in LCR, if it is not, send somebody to Salt Lake, sector 5, bring the report, then we will consider the case. Petitioner. Petitioner is aggrieved by the continue, or should I give it to the next circuit? আমারও মনে হচ্ছে time লাগবে এটা।
It will take time. So you have to ascertain.
Whenever you receive these cases, inform the investigating officers. They start the cases, but all on a sudden they will submit the charge sheet without the record. And after the
Mainly case depends upon
that one part. Second, he is transferred and nobody cares about that. And the court is saddled with a case without any fate. Petitioner has challenged the continuance of the proceedings.
Till that my stay may be extended, lordship.
SPC is what? Commissionerate.
Especially.
You have one cybercrime police station.
Lordship initially one, only one.
আচ্ছা, কি বললাম? Relating to cybercrime police station, case number 69/24 dated 6/7/2024. Wherein charge sheet has been submitted on conclusion of investigation. Learned advocate for the state has produced the case diary, but the case diary do not contain the report of the expert
Accordingly, state is directed, directed that the investigating officer of the case collects the expert's report, which is an essential part, which should be an essential part of the investigation. Records reflect that earlier by an order dated 10/2/2025, an interim order was granted by a coordinate bench of the court, thereby staying the proceedings of GR case number 2366 of 2024. Let the interim order so passed continue till 15th of July 2025. 24 not a 25, আগেরটা 25 হবে। হ্যাঁ না ওইটা GR case 24। আরে কি বললাম লাস্ট না এখন ডেট কবে পর্যন্ত দিলাম ইন্টিরিম অর্ডার till 15th of July 2025. In the meantime, the state will produce the report along with the CD report expert's opinion along with the case diary in the next available circuit bench when the revisional application will appear under the same heading. Accordingly, CRAN 1 of 2025 is disposed of.
Evidence service.
Evidence service file be kept with the record. Next.
Lordship, I am for the petitioner.
For the private.
Lordship, on the at the initiation, the interim order was passed and on that day private party appeared before the honorable court. And on that day, the private party was directed to file exception, if any, within 7 days. But that has not been matured till today, number one. And thereafter, the matter enlisted before the before the coordinate bench. The coordinate bench, honorable coordinate bench has directed the parties to settle the dispute, as the amount is big one, considering that the dispute is purely of civil in nature. Now, an attempt was made, but that is not fruitful. So I like to proceed with the
What is you have come for? What quashing?
Quashing.
Which year case? 24 charge sheet submitted?
No, not submitted. Not submitted. Initial stage, but
11th of September এই মামলায় কিছু নেই, charge sheet not submitted.
Not submitted.
You are most state is silent.
I may be permitted to file an execution opposition.
না কোনো opposition হবে না, সিডি দেখবো ওয়াশিং অফ এফআইআর আবার opposition কি? Sir, when did you receive the CD? Oh, CD, you know, receive bring the CD. Will you produce the CD? I'm keeping the matter. It's a Malbaja. How much time you require? Monday.
Lordship, Monday, Tuesday.
Tuesday. Tuesday, mamla complete করে দেবো, সিডিটা নিয়ে আসুক। Sir, now you have got to be tough with the police authorities, sir. When you register a case, you have got to conclude that these are not cases which will continue for time immemorial. You see 3 crores amount over there, you get allured and register the case and then force the parties to settle. These things have to stop, sir. Otherwise, if police authority, civil courts are there, they can go and settle the disputes. Other also forums are there, but on arrest, if you try to do these things and settle the matters, things would become worse, sir. Send them for complaint cases to do complaint cases. But why police will be bothering in such private dispute where part payments and all this? He's saying payment by cash and they are registering the case. I understand in Ponzi schemes these are done, it's all right. But absolutely private dispute, business dispute. এ লিখেছে একটা কেস টেনে দিয়েছে, তাহলে তো দেখাতে হবে যে কি কি কালেক্ট করেছে, বিকজ September 3 months and these 5 months have passed, 8 months.
And this FIR is also after 1 year with some new thoughts.
But you are enjoying the money.
No, no, lordship, not that. Not that from their, from their,
The amount is still due.
from
You have the documentation.
their email, it will reveal that the entire money has been, in lieu of money, tea leaves were delivered. But they are not giving the accounts, only this is the dispute.
File your accounts, I can file your accounts simultaneously.
Oh, that you settle somewhere else, sir. What is it? You are from where? Meteli? Meteli?
Meteli.
ওই জন্য থানা ফেভারে হয়ে গেছে, কোনো রেজিস্টার করে দিয়েছে, থানা কোনো স্টেপ শিখছে না।
Lordship, we are from Malbajar and another Meteli.
Krishna is from Malbajar sir, and Esponamati from Metlis.
গল্প করে লাভ নেই, শেষ করে দিয়ে চলে উঠে করি। আচ্ছা, state is directed to produce a case diary on 17th of June 2025 when the revisional application will appear under the same heading. I'll complete the matter on that day. Either side you have got to accept. Mr. Bhomik not going to Supreme Court?
No, madam.
Supreme Court গেলে মার্বেলের কোয়ালিটিটা ভালো হয়ে যাবে কিন্তু।
Lordship, grateful lordship.
বুঝতে পারলেন তো? হ্যাঁ, 6 বছরে যদি লিন্টার্ন করতে আরম্ভ করে মার্বেলটাও ভালো নিতে হবে। হ্যাঁ। Yes, sir.
I'm for the petition in this case.
Extension of the interim
There's
order.
an extension, application for extension of interim order granted earlier.
Order by the first previously my lord on 19 February 2025. Just excited to what time.
The petitioner is a government employee, my lord. The claim is FIR is not disclosing any offense against the petitioner, my lord, but subsequently the petition has been tagged. The petitioner is
The case of 23 charge sheet not submitted?
But case diary, I am not holding the case diary, my lord.
Bring the case, what is this?
Yes.
23 মামলা,
Yes,
25 FIR stay নিয়ে
But
যাচ্ছে।
kindly, this is a.
My lord, I'm not a named FIR. My lord, I have
Whatever
submitted-
is there, some decision has to be taken, sir. Either you should be discharged from the case or it will be quashed. This is a forgery, document forgery case. November 2023, FIR was registered.
But kindly placed it on Tuesday, my lord.
More than 1.5 years have passed. Come back on Tuesday, sir.
My lord, in the meantime, that interim order be extended.
Or for 4 days, no interim order is.
Till the Tuesday, my lord.
When is the next date?
My lord, I was not ever a part of the dispute only, my lord. But my lord, subsequently I was issued notice, my lord, which constrained me to before this court. Man, I am an employee of the government of West Bengal, my lord. I am the district sub-registrar, Darjeeling. Okay.
So your stay was till 19th of May only.
Yes, my lord, a CRAN has been filed.
The CRAN has been filed.
Yes,
Your
my lord.
police, if police listens to CRAN,
No, my
then
lord,
it will listen for 4 days on also.
it was my humble prayer, my lord, I
Uh-huh.
beseech to my lords.
For the last 21 days, sir. Today we are on 11th.
Yes,
19th year expired interim order. The 11th, that side and 11th, 22 days. If by way of pendency of an application, you are successful in stalling for another 4 days.
no, my lord, we are not stalling anybody, my lord. We are still ready to
Produce the
cooperate.
case diary, produce the case diary. I'll dispose it of. চলে আসুন, চলে আসুন। তো কাঁচা মামলা তুলে দিয়েছে আমার কাছে, ভুলভাবে তুলে দিয়েছে, আমি বলে দিয়েছি এক্সটেনশন নিয়ে পালিয়ে যাবে আমার কাছে। হ্যাঁ একটু তো হবে না, মামলা শেষ করে দিই ছেড়ে দেবো, যেদিকে যাবে আমার কাছে পড়ার। এখন state is directed to produce a case diary on 17th of June 2025. When the revisional application will appear under the same heading with the connected application. Cholo, come on Tuesday, sir. Grateful. You were what?
My
ADSR?
affidavit,
ADSR?
I was ADSR at that point in that relevant, now I'm transferred to Darjeeling, my lord, I'm DSR Darjeeling.
This is what complaint case or what's?
Yes, my lord, the FIR was started after there was a
After?
After there was a complaint case, there was a 156.3
So
filed.
there is FIR.
No,
Still,
there was a complaint case, 156.3 was filed and it was allowed, and after that it was transferred into a FIR and the investigation was started. Charge sheet has already been filed, my lord. Before filing the charge sheet, what happened, there is a dispute between the
That I understand. So therefore, state is required. You are appearing. You are state. Who is state?
I go to opposite party number 2.
Produce a case diary.
My lord, the dispute.
I should let him produce a case diary, sir. Had it been a complaint case, I would have heard both of you. But since case diary would be required, state is a.
Friday, my lord. Or Monday, my lord.
সব মানডেতে করতে পারবে তো, তারপরে তো অন্য ঘরে গিয়ে বসে থাকছে।
না, অন্য ঘরে কোথায় যাবে? ঘরেই করবে।
In the morning you are not available.
In the morning, একটা matter. There's only one matter.
Matters are 1 or 2, sir. If you are 100 matters a day, you will not be staying at Jalpaiguri. You will be saying, I'm virtually will be appearing for Delhi. Huh? So matters in High Court would be 4 or 5 in a day. You can't have like the trial courts that you will have 20 matters or 25 matters. If you have 100 matters or 20-25 matters, you will be virtually appearing. You can't physically appear. Possible to physically appear if you have 25 matters? No. Petitioner is a learned advocate was a petitioner. You will not be coming. Which date you said you are convenient? Tuesday. Learned advocate 8 for the petitioner as well as the private opposite party is present. Mr. Biswas appears on behalf of the state. Is directed to produce the case diary on 16th of June 2025 when the revisional application will appear under the same heading. 16th. Next.
May I file the affidavit of service?
Is under which section, sir?
Under 406, 417, 420, 323, 506 of the Indian Penal Code. my lord.
You are appearing? Got the case diary?
Yes, sir.
My lord, the allegation is, my lord, I am a tea seller. So I purchased certain quantities of tea from the complainant. Now some amount were paid, other, my lord, apparently.
Complaint is to interest statute. Where do the complainants stay?
My lord, here only I have served, my lord.
Oh, served when, sir? Not
Served.
in close proximity, I believe.
No, may I just see the, because very close.
But all on a sudden, it's the first time it has come in this circuit, na?
Yes, we had prayed for extension of interim order, that is.
No, but they must be present, sir.
Yes, yes, I understand. 9th of April, my lord, it was served.
On the last occasion, they were present.
They were present, so inform the learned lawyer or phone.
Last occasion.
Oh, they were present.
No, last occasion it appeared for the first time.
First time expertise order.
This is the second occasion, my lord. Very well, my lord, I can serve.
Who appears for them?
Yeah, I have no idea.
Already, sir, where do the opposite parties stay?
No, opposite party stays here only, my lord. Siliguri.
Shevok Road, Jalpaiguri Road.
Shevak Road, Siliguri, my lord. District Jalpaiguri, but in Siliguri.
Oh, serve kore debe. Give a copy to him. To
Copy has been
officer,
served.
he will effect service.
Copies have been served.
The copy, I have the copy.
No, no.
State has the copy, my lord.
To the police, if it is served, the acknowledgement will be there. That will be, then
Yes,
we
your
can
lord.
take up the matter.
Yes, yes.
That will be easier for me. So, Rashunto, the petitioner is directed to hand over a copy of the revisional application upon Mr. Chakraborty, learned advocate appearing on behalf of the state. Preferably by tomorrow. Learned advocate A for the state who would communicate with the officer in charge of Okinawa Police Station, who would inspector in charge, who would depute an officer, depute a police person for effective in service on the opposite party number 2. A report is submitted before the court on the next date, on next date, on on 18th of June 2025, when the revisional application will appear under the same heading, along with the connected application.
My lord, praying for a limited extension, my lord.
No,
it was there, it is still.
That was exported.
Yes, till the first week, my lord, till Friday.
If they don't turn up on that date, I will extend them.
As your lord.
For the petitioner, item number 56, lordship.
You state.
This is my affidavit of service. My lord, this is an application for quashing of the first information report, lordship.
Charge sheet submitted.
Charge sheet submitted, lordship.
Lord, I'm holding the CD.
Give me the CD.
May I proceed, lordship?
I'm keeping the CD tomorrow. Do the matter. Tomorrow do the matter. Let me go through the case diary.
Lordship. I have
Tomorrow
submitted my affidavit of service, lordship.
You are appearing for the opposite party. এটা কি পাস এটা এটা আমার বাড়িতে পাঠিয়ে দিন তো দেখে আসি তাহলে তাড়াতাড়ি হয়ে যাবে just check it then I'll allow it. না না কি tomorrow she's appearing tomorrow give the affidavit so if I'm not passing any order I'm retaining the case diary only এটা বাড়িতে পাঠিয়ে দিন আর লিস্টে এখানেই রিটেন করে রেখে দেবেন
আমি ওরা অ্যাপিয়ার করছি তাহলে নাম দেওয়া দরকার অবলাইজ লর্ডশিপ
By evening.
In this matter, this OP number 2 claiming herself as the legally married wife of the petitioner number 1.
Lordship, I have received the instruction to appear in this case, Lordship. I have not received the brief yet. Kindly keep it next week, Lordship.
করার নেই কি করে রাখবো
17th
নেক্সট অ্যাভেলেবল সার্কিট সবই ব্রিফ পেয়েছে এখন কি করে করবে
Proceed, Lordship, please.
You give your name and address to him, sir. This is the greatest difficulty. Next day you will not be available.
No, Lordship. Then I come regular.
Have you filed your power?
Yeah, today. Today is the back power.
রেকর্ডে পাওয়ারটা আনিয়ে নেবেন তো নিয়ে রেখে দেবেন যাতে অন্তত নেক্সট দিনে পাই না হলে অর্ধেক মেনশন হচ্ছে কোনো মামলা হচ্ছে না learned advocate for the petitioner state and the state is present. Learned advocate for the private opposite party number 2 enters appearance and submits that he has been engaged only today
and is not ready, A, for conducting the hearing. Accordingly, list the revisional application before the next available circuit bench. State would produce a case diary on the date so fixed.
Deeply obliged.
In this matter, Lordship, I beg to appear on behalf of the petitioner in item number 58, Lordship. Am I audible, Lordship?
Audible. Your opinion?
Lordship, petitioners were about to start a business with the victim, Lordship, business of PC culture, Lordship. And the victim was a trained electrician, Lordship. He was getting his mobile phone charged by hooking. At that time, Lordship, he was found in electrocution, Lordship. What happened, Lordship? In this matter, petitioners approached before this honorable court praying for anticipatory bail, which were rejected. After such rejection, when they approached before the honorable apex court, since the chemical examiner's report that was not available pertaining to the post-mortem report of the victim, state was directed to submit the chemical examiner's report before the learned trial court. Thereafter, Lordship, the case record that was not available. And in the meantime, Lordship, 27/11/2024, warrant was issued against these three petitioners. Four accused persons are there. One of them was arrested, Lordship. On 27/11/2024, warrant of arrest has been issued by the learned ACJN.
Case is under which section? 306?
302.
302.
2.
302 কি করে হবে?
2.
Actually, this mobile phone story is not mentioned in the FIR. Page 11. It is there.
So how did the person die?
Lordship, the case diary is required. The postmortem.
Okay, diary nahi thala. Tomorrow bring the case diary.
Lordship. Lordship.
The Tufanganj is far away. Just wait.
Lordship.
Far away. Huh? Tufanganj, Friday possible or no? Next week. Wednesday then. Next Wednesday, huh?
Lordship.
And you get all the instructions whether chemical examiner's report has been received or not. Acha, learned advocate aid for the petitioner is present. Mr. Ganguly appears on behalf of the state and submits that case diary is required. Let the case diary be produced on 18th of June 2025 when the revisional application will appear under the same heading.
Lordship. I'm grateful.
59, I am appearing on behalf of the state, my lord. Can you?
Who is appearing?
I'm for the petitioner.
Yes, Otto, say. Yolo.
Yes, my lord.
My lord,
This matter.
I'm led by Mr.
My lord. Mr. Aditi Shankar Chakraborty will be appearing in this matter. We need the original CD, my lord. So can it be fixed on 16th, my lord?
16th সব মামলা হবে?
It's one matter.
বলছি
My lord, make it read on 16th in that case, my lord.
learned advocate.
Earlier, assisting the public prosecution. Today, informant yesterday, I was in will not be assisting, helping her in this case. So as I was already engaged in the lower court, I came yesterday, filed by court number A618. In my submission in this case today.
The basis of this presumption prosecution will not.
No, prosecution, obviously, you cannot take the stand. Up to that, you are correct. I'm not taking it. But you are appearing in your personal capacity, not as a legal aid lawyer.
Not legally, I'm
Yes, you file, obviously, professional, why can't you?
In these cases, fixed for regular evidence on 16, 17, 18.
I will hear it, 16th, I will hear it. You are wanting on which date? You tell me. I've got to see no use keeping the matter pending over here. Either way, the matter has got to be disposed of. So have a consensual date, I'll fix that date only. Which date will be convenient?
30th June 30. If it is possible. Because I'll be going back tomorrow.
Huh?
I'll be going back there to get it tomorrow.
Not possible, the circuit is up to.
So, why not 16, 17, 18, anything?
16.
That's why I was saying, we wait for
16. Learned advocate 8 for the petitioner, comma, state and the de facto complainant is present. Yellow. Learned advocate 8 for the state submit that the original case diary will be required. As such, let the revisional application be fixed on 16th of June 2025 under the same heading.
Grateful.
বেকার তুলে এগুলো মামলাটা তুলেছে কে? মেনশন করে দিচ্ছে অ্যাপিয়ার করছে না। নেক্সট কে ডিপার্টমেন্টে পাঠিয়ে দিচ্ছে। You are appearing?
That's
60.
I appear for the petitioner Santosh Prasad.
Yes.
Who is aggrieved by the imprint order dated 16 December 2024, passed by the Learned Special Judge Electricity Act. Under section 136(1) of the Electricity Act, Your Lordship. By the said imprint order, a warrant of arrest was issued against the petitioner and proceeding under section 446 CRPC was initiated solely due to the
Earlier you were on bail.
Yes, Your Lordship.
Earlier you were on bail.
Yes, Your Lordship.
Where is the bail order? That's all. Why don't you read your brief and come?
Page 12, Your Lordship.
Page 12. You are Santosh Prasad?
Yes, Lordship.
ঠিক আছে। 2016 bail. How many days you did
Case
not
is-
appear?
Only once, Your Lordship. This is the first instance, Your Lordship.
Absent, see at the bottom of the page, accused is absent by filing petition.
Time petition has been filed at it, Your Lordship.
Absent though.
It's Lordship. The case is pending. Your Lordship, may kindly see, charge sheet was submitted on 31st March 2016. The first PW witness was examined on 3rd December 2018. Thereafter, after 5 years, Your Lordship, the second PW witness was examined. That on the both occasion, the petitioner was present, Your Lordship. It's been 9 years.
Where is your client staying?
He is staying in Siliguri, Your Lordship.
So go by Monday, surrender, you will continue on the same bail and bond. All right?
Grateful, Lordship.
And appear over here with a copy that whether you have surrendered or not.
Lordship, great.
All right? Mr. Chakraborty, somebody appeared warrant of arrest is in Electricity Act, let him go. He was on earlier on bail, let him go. If he appears by Monday, let him continue on the same bail and bond.
I have to ascertain the.
From the public prosecutor.
Grateful, Lordship.
কিন্তু ফেলে দেখে কোনো লাভ নেই, বেকার পড়ে আছে মামলাগুলো। Yes, Mr. Luksam, huh? Petitioner has approached his court being apprehensive regarding the warrant of arrest issued by the learned judge special court under our EC Act Darjeeling on 16/12/2024. Records reflect that the petitioner was earlier on bail. The case was initiated in the year 2016. Having considered the fact that the petitioner is already appearing before the court for about 9 years, I direct that in case the petitioner appears on or before 16th of June 2025 before the learned judge special court under EC Act Darjeeling,
the petitioner would be allowed to continue on the same bail and bond earlier furnished before the learned special court. Acha. A copy of the revisional application may be served upon Mr. Sarkar, learned aid advocate who ordinarily appears on behalf of the state. His appearance may be regularized by the concerned authorities. Learned advocate aid for the state will submit a report to the learned public prosecutor appearing before the learned judge special court under EC Act Darjeeling regarding the accused of the petitioner appearing before the learned special court within the time period so fixed. The revisional application will appear under the heading to be mentioned on 17th of June 2025. You surrender in the weekend, Friday, obtain a certified copy before this court and dispose of them. কেন কি আছে? কোথায় গেলে এতগুলো? ইউ আর মিস্টার ভৌমিক জুনিয়র? হ্যাঁ, হয়তো হবেই না, কোনোভাবেই হবে না।
Kindly lordship.
হ্যাঁ, চা বাগানে মামলা নাকি?
হ্যাঁ।
21/3/2000 সিআর কেস তো। The 138 Quashing এসছে নাকি? 138 ওয়ারেন্ট কি? ওয়ারেন্ট এক্সিকিউশন হয় না এখানে?
Second time, and there's a chance that he may be. First time warranty আছে. If second time.
This person, ভাস্কর মজুমদার। ভাস্কর 10,000 টাকা দিয়েছি জমা? হ্যাঁ? হ্যাঁ? হ্যাঁ?
That's why your senior has asked for that.
Not today, asking to come tomorrow, not today, এটা করে দাও। এটা not today, কালকে রেখে দেবে। আর একটা পাস ওভার আছে একজনের মামলা।
Forty-three.
Yes, madam.
Page number 14, charge sheet.
Do it tomorrow. Any urgency? Tomorrow you can do it.
Yes, madam.
Not today, কোনো আর ভালো লাগে না মামলা করতে। অনেকগুলো সই করতে হবে এখন।